Just doing a quick sound check.
Yep, we can hear you just fine. Thank you.
Cool. Okay, it is 9 o'clock. Are we okay to get going? Everyone in the room?
Yes,
Yeah?
Madam Chair.
Thumbs up. Great. Welcome to the June 17th Mineland Reclamation Board meeting. My name is Nell Wareham. I'm the chair this month. This is a hybrid meeting, as you can tell. So let's start out with some roll call of the board members. Mr. Oren?
Here.
Present. Stiegelmeier?
Present.
I'm here. Nelson?
Present.
Baker?
Here.
Tarrant?
Present.
And Padilla?
Here.
Great. Got the whole group. Okay. Just again, a reminder with some of these hybrid things, if for some reason you can't hear something or need to unmute, let us know, make it known. Sometimes we can't all see every single frame in the gallery view, but hopefully this will go smoothly. We're going to start off with the approval of the May 2026 summary of minutes.
I'll make a motion
Stiegelmeier,
to approve.
I second it.
second Baker. Any discussion? Okay, all those in favor, please signify by saying aye.
Aye.
Hearing none opposed, that passes. We have a pretty good chunk of approval of continuances and withdrawals. So depending on which version of the agenda you have, it may have some different numbers in the initial items of the agenda. But as it stands now in the final agenda, we have item 4A is a consent. This is the Cripple Creek and Crawford. Gosh, I'm not reading right. Cripple Creek and Victor. That one is on the consent. There's also a consent, used to be item number 5. It's now 4B for Northwest Aggregates. Number 5 is moved to consent. This was also Northwest Aggregates. We have a withdrawn number 6, Larry Chartier. Number 7 withdrawn, Glade LLC. So that's item numbers 4A through 7 on your agenda. 3 in consent and 2 withdrawn. Do we have any motion for that?
Madam Chair. Yeah.
Yes.
Thank you, Michael Cunningham, Division Director. I just wanted to note for you that we do have a representative here present in the audience from SSR for the Cripple Creek and Victor gold mine item. They have requested to make just a brief comments to the board, if that's okay
Sure.
with the board chair.
Yep, that's fine. Is that appropriate to do right now?
I think
No, Madam Chair, if you wanted to do that when the consent comes up, I don't know if you wanted to just get approvals on the withdrawals first and then
Okay.
director reports, whatever works.
jump the gun on that.
Then after director reports?
Yeah, typically.
Okay, we can do that. So approval of the continuances and withdrawals, and then we'll do that. And thanks for flagging that for me, Director Cunningham. So do we have a motion?
My motion.
Baker?
Approve the withdrawal.
Second.
Okay, Nelson, any other discussion aside from what was flagged?
We need to do the minutes too. Oh, great.
We got minutes.
Okay. All those in favor, please signify by saying aye.
Aye.
Okay. Any opposed? Okay, thank you. Let's hear from the Executive Director's Office. Padilla?
Thank you, Madam Chair. Wendy Padilla, Deputy Executive Director for the Colorado Department of Natural Resources. Just wanted to give a drought update. Governor Polis has activated phase 3 of the state's drought response plan and issued a statewide drought emergency declaration in response to worsening drought conditions driven by record low snowpack and persistent warm temperatures. The declaration builds on efforts already underway and allows state agencies to continue coordinating resources, monitoring impacts, and preparing for additional potential response actions. The Colorado Water Conservation Board, through other partners with state and local governments, the agriculture community, continue to work together for months to track conditions, support communities, and advance immediate response and long-term drought resilience efforts. On the Colorado Department of Natural Resources website, there are water conservation resources and drought resources. We have worked with the Department of Agriculture, Colorado Water Conservation Board, Colorado Parks and Wildlife, Division of Reclamation, Mining and Safety, and our wildfire mitigation program to bring resources together all on one website where folks can find information about funding opportunities, both long-term and emergency funding opportunities, how to live wildfire ready, information about coal mine fires and drought, water administration and drought with Division of Water Resources leading that, and mountain snowpack conditions. Our Colorado Parks and Wildlife continue to conduct fish salvages in targeted areas. And on this page, there are explanations about how they determine when a water should be closed to fishing. So a lot of resources there, and wanted to bring your attention to that. I can send that out to all the board members if you all would like to see that webpage. And with that, that concludes my comments. Thank you, Madam Chair.
Thank you. Any discussion or questions?
You'll send out the webpage.
Any updates on Ponderosa pines? I saw a lot of dead ones driving down here.
Our mountain pine beetle task force continues to meet. They met yesterday actually in Teller County and Divide, Colorado, and continue to coordinate things like funding, the mapping behind it. So this is going to be a long-term effort where we're trying to get state agencies with their resources to coordinate long-term. But they do have a mountain pine beetle task force webpage and resources for governments, homeowners, things like that. So unfortunately, it's going to be a long-term problem that we're all marshaling together to point in the same direction to solve.
Great, thank you. Executive Director's Report, Mr. Cunningham.
Thank you, Madam Chair. Good morning, members of the board. First, just want to wish everybody a happy summer, which officially kicks off with the solstice coming up this Sunday. So we're fully in field season mode. Staff are busy traveling around the state, conducting inspections, carrying out reclamation projects, and performing trainings, and staying incredibly busy. I'd like to just let the board know that our new 110 reclamation only permit is live on the website. So we're incredibly excited to complete that work and have it out there live for the public. We approach this as kind of a, if you build it, they will come scenario. And so we've done that. We've built and established that new 110 reclamation only permit. And we're looking forward to receiving some of those first applications later this summer. We are also on a personnel front, conducting interviews for new environmental protection specialists next week. This is to fill a seat that was vacated by Ursula Armstrong, who went to work for one of our sister agencies, Energy Carbon Management Commission. And then also incredibly excited to announce to the board that Jenny Bussum, the division's new GIS coordinator, will start with us next week. Jenny comes to us from the Department of Law, and establishing this new position was part of our strategic planning and priorities. We still have a long ways to go to set up an internal GIS program, but this was a very important first step to build out the program. So we're excited for her to join, and I will introduce her to the board at next month's hearing. And lastly, just want to note for the board that tomorrow staff will gather to celebrate the Division of Reclamation, Mining and Safety's 50th anniversary, along with the state's 150th anniversary and our nation's 250th, which will occur in just a few short weeks. So as we sort of reflect on the founding of our state and the division, it's impossible to ignore the role that mining had on the formation of our state, including where towns were established, how the economy grew, even how laws were established, including our system of water rights. I learned recently that Colorado is only one of 2 states in the nation to have a water court. The Office of State Engineer, which was established in 1881, one of their very first water rights administered was for the Swan River Mining Company, which granted the right to change a water rights place of diversion and place of use. From that time, mining continued for about another 118 years, largely without any regulatory oversight. Colorado state mining laws were developed in the 60s and 70s. The Open Mining Land Reclamation Act of 1973 established a permit process and limited bonding for coal and other industrial mineral producers. And it wasn't until 1976 that the Colorado Mine Land Reclamation Division was created under the Department of Natural Resources to regulate non-coal mining operations. So our division has existed under different names and structures with different statutes guiding our work over the last 50 years. As I look back on the work that we've done and the progress we've made in advancing reclamation science in Colorado, I am continually impressed by the work performed by staff, and I'm honored to be part of this team and the legacy that we've created. And so we're looking forward to getting out and doing some celebration with staff tomorrow. And with that, that concludes the director's report. I'm happy to take any questions from the board.
Great. Any questions or comments? It's a busy summer. Okay, so coming back to item number 4, which was previously item number 10, it's now on the consent agenda. We have a few folks from Cripple Creek and Victor that just wanted to make a few comments. Is that correct?
Yes, Madam Chair.
Okay.
Great, good morning.
Good morning.
My name is Lou Billingsley. I joined the Cripple Creek and Victor mine as general manager just this April. First, thank you for the opportunity to address you today. Obviously, have a busy agenda, a lot going on. As a Colorado Springs native, a Colorado College geology graduate, I truly understand the importance of the mine to the community and the importance of strong stewardship of our natural resources. I've spent my career in mining, including here in Colorado, previously as the general manager at CC&V in 2014 and 15, and I additionally spent almost 20 years of my career at Cripple Creek, and Victor. I truly do understand the importance of the regulatory requirements for the safety of our people and the protection of the environment and the community. SSR Mining acquired CC&V in February of 2025. And through our leadership change, we continue to evaluate our operations and strengthen and improve our procedures and controls. I wanted to briefly address you today to confirm our commitment to ensuring the mine's future and its work to do so with environmental rigor and the safety of our employees front of mind. Cripple Creek and Victor, we accept the consent agenda and we appreciate the division's support throughout this process. We're committed to completing all of the corrective actions and to continue the open collaboration with the division staff. As a new operator of CC&V, SSR Mining is committed to responsible stewardship of all of the environmental protection facilities across the mine site. We will use this event as an opportunity to strengthen our systems And we're committed to driving improvements, not just on the Valley Leach facility, but across the entire operation. Upon investigation, we confirmed that the liner had not been contacted or damaged. The environmental protection facility remained intact and functional. We completed the liner replacement with full QA/QC documentation, which has been and have submitted it for recertification, and we're working with the division through that recertification process prior to resuming leaching activities. We have completed an in-depth incident cause analysis and will re-verify, retrain, and improve our use of several critical controls to prevent a recurrence. This includes use of advanced GPS avoidance technology, giving equipment operators real-time engineered boundaries on the Valley Leach facility. Physical field staking by our survey crews independent of that GPS system as a backup to provide visible, redundant boundary controls at the critical first lifts against the drain cover fill. We also are doing a comprehensive review and update of our dump and Valley Leach facility management standard operating procedures and governance document covering the full cycle of VLF stacking from lift design through field execution. And of course, retraining of all of the operators and supervision working on around the leach pad. We certainly appreciate the board's time today and the division's collaborative approach throughout this process. We are committed to completing the remaining corrective actions on schedule and to maintaining open communication with division staff. Thank you very much.
Thank you very much. We appreciate those comments and your willingness to work with the staff. It's always great to hear. Best of luck with the rest of it.
Great, thank you very much.
Thank you. Anything else on this item, Director Cunningham?
Nothing further.
Okay, sounds good. Thank you so much, gentlemen. All right, so we are moving over to what should be number 8 on your agenda. This
Hang on.
is,
Madam Chair,
Yeah.
just need
do you want
to approve the consent
to
agenda.
approve it again since with those withdrawn comments? Sure. So we approve the consent agenda, but we need to approve the items that are withdrawn, which is 6. Oh, sorry, the whole consent.
Yeah, I think it's the other way around.
Yeah, you're right. Okay. Let's just see how interesting we can make it. Okay, we need a motion to approve the consent agenda, which includes the Cripple Creek item, Northwest, 2 items from Northwest Aggregates, and Larry Chartier and Glade LLC.
I'll make that motion.
Thank you.
Second.
Second, Nelson. Any other discussion? Okay. All those in favor, please signify by saying aye.
Aye.
Any opposed? Okay. The consent agenda passes. Thank you. Okay. Now we are on 8, which is M-1981-86. This is Northern Colorado Water Conservancy District. This is a consideration of a petition for declaratory order to exempt the permittee from the requirement to post financial warranty. Brock Bowles will be taking this one over from a staff consideration. Do we have anyone else in the room I need to swear in?
Yes, Sean Henry is here representing the Northern Colorado Water. He's online.
Okay, great. Does everyone swear to tell the truth?
Yes.
Yes?
Yes.
Okay,
Good morning, everybody.
great. Sounds good. Okay, so we'll have a brief presentation from Brock Bowles on this one.
I don't know if you want this up.
Okay, yeah, that works. Good morning. My name is Brock Bowles with DRMS, and this item actually has 2 items. It was listed as 2 separate items on the list. It's the same operator, but it is for 2 different permits, and they're both asking for a declaratory order. Both of these permits qualify under our rules as being exempt because it's the same operator.
Okay, so just really quickly, when we are listening, are we essentially listening to consider both item 8 and item 9, or do we need to be separating things for votes? Just want to make sure are you suggesting we combine it or not?
I'm combining it into one presentation, otherwise it would have been two very repetitive presentations.
Okay, but if there's a subtle difference, the board is listening to this to vote for two separate requests still.
Yes.
Okay, does everyone understand that?
Yes.
Same
Sounds
offer,
good.
same
Yes.
general reason why they're asking for this, but we are gonna go through it twice in terms of a vote. Okay, thank you.
Okay. So this is a board action for a declaratory order submitted by the Northern Colorado Water Conservancy District. And this is for, again, two files, M 1981-085 and 1981-086. And just for the record, both of these permits are back to back on the landscape, same piece of land owned by the Northern Water Conservancy. So these permits almost look alike on the land. They're just two pits back to back. Okay, so a declaratory order was received from the Northern Colorado Water Conservancy District on April 30th, 2026. The DO is asking the board to consider whether Northern Water, a quasi-municipal cooperation, is subject to Rule 4.1.2 Parent 2 and therefore not required to post a financial warranty. A copy of the declaratory order was included in the board packet. So Rule 0.25 states that any person who is or may be directly and adversely affected or aggrieved and whose interests are entitled to legal protection under the Act may petition the board for a declaratory order to terminate controversies or to remove uncertainties as to the applicability to the petitioner of any statutory provision or any rule or order of the board made pursuant to the Colorado Land Reclamation Act for the extraction of construction materials. So the petition submission, the process here for declaratory order, in Rule 2.5.2 Parent 1, the petition must be submitted at a minimum of 7 days prior to the board meeting at which it is to be considered. The petition for the DO was submitted by Northern Water on April 30th, 2026, which is more than 30 days to this board. The petition submission Rule 2.5.2 Parent 2, any petition filed pursuant to the rules shall set forth the following: name and address of the petitioner and whether the petitioner is a permittee pursuant to the Colorado Mine Land Reclamation Act. Northern Water is a permittee for both of these permitted sites that are listed: the Riprap Quarry M 1981-085 and also the Borrow Area C M 1981-086. Pardon me. So continuing with requirements of Rule 2.5.2 Parent 2, the statute or rule or order to which the petition relates. The applicant stated in its April 30th, 2026 letter that the statute related to the petition is Rule 4.1.2 Parent 2, and no financial warranty shall be required where the operator is a unit of a municipal or county government or the State Department of Transportation, and the operator submits a written guarantee in lieu of a financial warranty, stating that the affected lands will be reclaimed in accordance with the terms of the permit. These rules and sections 34-32.5-116 So continuing on with that, Parent C, a concise statement of all the facts necessary to show the nature of the controversy or uncertainty and matter in which the statute or rule order in question applies or potentially applies to the petitioner. The applicant stated in its April 30th, 2026 letter that Northern Water meets the guidelines and status for a unit of municipal or county government being a quasi-municipal corporation and political subdivision of the state of Colorado, governed by Special District Act, Section 32-1-101. Are there any questions? That was just a very statutory presentation. The division at this time, we don't have an opinion about this subject. It's not something that's really governed by the other parts of the rules. This is a declaratory order subject for the court to consider.
Okay, thank you. And then Sean Henry, I believe did you have anything you wanted to weigh in here or make any comments?
I really don't. I mean, I'm happy to answer any questions. I think this is a permit from 1981, so longstanding permit, active quarry for us for fire recovery, stabilization work, maintenance of the Colorado Big Thompson project, and then our gravel pit as well, for similar operations and maintenance and fire recovery work. So really critical for operations, and also leased to Grand County for some of their road and bridge operations. So happy to answer any other questions.
Any questions from the board? If you haven't been on the board for quite as long, this is something that we do see fairly, not frequently, but it's not super rare to have this conversation when it comes to municipalities or some of these conservation districts. So, at least from the seat where I'm sitting, this sounds pretty similar to other conversations we've had around this issue. Okay, are we okay to entertain a motion, Brock? Is there anything else you want to add here?
No, ma'am, that's all I have to add. Thanks.
Okay, so procedurally what we're going to do is even though we saw the presentation, same general facts and reasons for both permits, we need to vote on these separately. So the first one is going to be if we have a motion for file M-1981-086, which is the consideration petition for declaratory order to exempt the permittee from the requirement to post the financial warranty. Motion?
Make that motion.
Second?
I second.
Any discussion? Okay, all those in favor, please signify by saying aye.
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 Those opposed, same sign. Okay, hearing none. Number 8 passes. Thank you. And then moving along to number 9, this is file M-1981-085, Northern Colorado Water Conservancy District. Same thing, consideration of the petition for declaratory order to exempt the permittee from the requirement to post financial warranty. You have a motion?
So moved.
Any seconds?
Second.
Second, Nelson. Discussion?
I have a question.
Yeah.
It seems like if this special district fits all of that, why does it need to come in front of us? It seems like it should be, once it's done, it's done.
Madam Chair, this is Russ Means for the division. It's a policy and stuff and that for the decision and stuff on whether a financial warranty should or should not be posted and stuff for this and stuff to have a board action as opposed to a staff action. So while we get these and stuff occasionally, and that the one thing that the staff does is it confers with the AG to make sure that the entity and stuff that does in fact meet those requirements. And if they do and stuff, this is the process and stuff and that, so that we have final board action and stuff for that it helps protect the operator just as much as also having that official document.
And how long does it last?
Oh, for as long as the permit's in place. Yeah, unless it succeeds operator or anything else. So it's like any other municipality, they put up a performance warranty and it leaves them of the requirement and stuff for the financial warranty for these water districts and stuff. That's a very, very big lift.
I guess I'm still unclear, why wasn't this already in place?
Oh, because they succeeded operator and stuff on the, did they not?
No, I truly don't know why. This was permitted back in 1981. And might have been an item that was missed, or maybe something changed in the meantime. I don't understand the history of why. It was just when I was doing my inspections, I was seeing that there was just a missed detail here, and I worked it over with Northern Water to see if they did qualify, and we just worked it and just put it through the process.
A lot of times these permits and stuff are succeeded operator by a water company or some an entity like that, and that's where I was referring to stuff that where it's lifted. So
Okay, thank you.
So yeah, I to answer your question, Ms. Stiglmeyer, like this should not then come up again. This won't come up in an annual review or anything, right? Where this is pretty much administratively cleaned up at this point, correct?
Correct.
Okay, so we had a motion and a second. We had some discussion. All those in favor, please signify by saying aye.
Aye.
Any opposed? Okay, so same thing with M 1981-085. Thank you so much for that concise presentation, and thank you, Mr. Henry, for being here to help support this. We are.
Thank you, everybody. Much appreciated.
Yep, thank you. Okay, so we have another kind of similar two issues on the agenda for us. Same operator, but two very similar, dissimilar reasons why it's on there. So just procedurally, bear with me for a second while I kind of get through this and set the stage for you. File number, or number 11 is file number M 1977-410. This is Grand Island Resources, LLC. This agenda item is a consideration of petition to intervene and petition for a declaratory order. We have some decisions as a board in terms of how we want to move forward with this. Patrick Lenberg, do you have anything you want to say before I try to talk this through with the board or anything? Not sure how you want to approach this one. Okay.
Chair, Jeff Hewitt here on behalf of the division. We don't have any preliminary statements. Obviously, staff is here to answer any questions the board may have. Mr. Koyman can also obviously field your legal questions. This is an odd process. Both of these matters deal with some declaratory orders and requests for reconsiderations that are not commonly petitioned for this board. Again, we're available to answer any procedural questions the board may have, but I'll defer to Chuck on legal advice for the board themselves.
Chuck, do you have anything you want to say, or do you want me to?
Yeah, I mean, I guess what I'd say is this first one is coming from a party that is, well, from an entity that's wanting to have party status, doesn't currently have party status, wasn't party to the hearing or the proceedings that have happened regarding the Cross Gold Mine in the past. And so, yeah, that's kind of where we're at with that threshold decision of, you know, what does the board want to do with this petition, and how do you want to proceed? You know, happy to you know, answer questions as we can, or as necessary as we kind of shoot through it.
Yeah, so just, it happens to be, just for context, as we were going through that previous item on, you know, Rule 2.5, which is sort of like, what are the guidelines when you're looking at a declaratory order? You know, is the party directly aggrieved? Are they directly affected by what's going on here when we are considering these matters? And just kind of, it's a little messy in terms of just sort of some of the procedural processes that went on here. This was kind of served before, you know, we even declared the board orders after the March 2026 filing. Not all parties were served. Again, American Clean Resources Group is not the owner of this mine currently or the permit being considered. So it's tricky to sort of see that they would be directly in line for the declaratory order. I think that you might consider I think it's appropriate for them to have some time to address the board, but in my opinion, it kind of almost seems like it might be better put into the public comment section of the agenda instead of a formal board action, because it's really sort of not the board's action, because this is about Grand Island Resources right now and not about how what happens might impact someone who's been trying to purchase this mine for 4 years but hasn't officially taken ownership.
Madam Chair,
Yes.
this is Chuck. I just do want to say, like, you know, the rules about declaratory orders, the process that starts is, you know, kind of a threshold decision on the board is whether or not they want to consider the petition. And so, and the rules provide that that can happen with or without notice to the petitioner. They're obviously here, so they're listening, they know what's going on, but it is within the board's decision to kind of like, well, I would say that's kind of like the first threshold is, does the board want to consider this petition? And, you know, Madam Chair, the factors you were talking about and that Brock mentioned with the previous item about, you know, is there a legally protected interest under the Hard Rock Act that the petitioner has here? That's a question that I think you would want to look at first in deciding whether or not to consider the petition. And then, you know, kind of the other factors that are in the rule. And, you know, happy to help you navigate that as necessary.
Madam Chair.
Yes.
I'm Howard Kennison. I am a shareholder at the law firm of Jones and Keller in Denver, former Deputy Attorney General for the state of Colorado. And I represent American Clean Resources Group, and perhaps I can clarify and make this a little more simple for the board. First of all,
Wait, just a minute. I want to see if that's where we are in the conversation here.
Okay, thank you.
I think first we were trying to discuss as a board whether we want to consider this petition.
Well, and I was going to suggest we are willing to withdraw the petition to intervene and to clarify the petition for declaratory orders. It would take me 2 minutes to do so.
Okay, so if that's on the table here right now, would the board just like to consider their thought about withdrawing this petition, but just give some clarification as to why they're interested parties in this issue? So what it kind of puts on the table is we're not needing to necessarily consider the petition if they're offering to withdraw the petition.
The petition to intervene.
To petition to intervene.
I think it would be helpful to hear some context.
Okay. So was everyone okay with hearing briefly from on this context? Okay. Okay. We'll give you a few minutes to give the board some context.
All right, thank you very much, Madam Chair and board members. As I said, we will, although we think we do have grounds to intervene, we will here officially withdraw that petition to intervene. And turning to the declaratory order, the petition, as you will read in that declaratory order, we have asked for 3 different things. One, for clarification on the financial warranty. ACRG itself is prepared to make a financial warranty once some of these preliminary issues for it are cleared up, but we will withdraw that request. We will also withdraw our request that the April 2024 board decision to end the life of the mine. We will withdraw that request under the declaratory order. The one request we would like to keep in place, and we believe we have grounds and standing to do so, is to ask this board to hold that April 2024 order in abeyance for a period of time to allow ACRG to complete its acquisition of the Cross Caribou Cross Gold mine. And Tawana Bain is here with me. She has about a 10-minute presentation which can explain to you how this situation with the Grand Island Resources and with the Cross Caribou mine can be cleaned up, and we can move forward on a very fresh start and get this mine permitted, clarified, and move forward on it. They are prepared to acquire it, but we need a period of time to run through some activities that Ms. Bain could present to you. We would prefer to do it right now, if possible. I will, of course, reserve the right for her to do it during public comment. But that, now on the standing issue, I'm happy to get into legal arguments with Chuck and with counsel, but I think that would be a waste of the board's time. And what would be more important here is to be a little creative, and let's just let ACRG explain what they are going to be doing with this mine and going forward on it. I think it might inform the rest of the day as well. Luana is here, prepared to speak.
Yeah, let me just pause here for a minute because I don't know if we need a 10-minute presentation quite yet. I'm just trying, I'm sorry, when we moved all of these numbers through the packets with all those other withdrawals and considerations, I'm not as it's not as easy to navigate to at the moment.
Madam Chair, this is Chuck.
Yeah.
Might be a good idea. I mean, I know there are several other interested parties, and kind of with the changing nature of the request and things dropping off and staying in. I don't know, kind of out of a sense of fairness, it might be good to have 5 minutes or a couple minutes from the other parties as well, sort of see where everyone's at. I'm not entirely, it's a little bit unorthodox, but I think we can, I mean, the threshold question still exists, whether or not the board wants to consider the petition. And I'm not sure where the narrowing has moved the needle for the board on that, or if it has or hasn't, or if it would be helpful to hear from other interested parties while the board is, you know, kind of at that threshold decision. But yeah, I'd kind of leave that up to you and the board to kind of cross that line.
And I also don't want to skip ahead too fast to what is actually item 12 with the actual party, Grand Island Resources, asking to consider the board's operator's request for reconsider of the board order, right?
Yeah.
So it doesn't seem appropriate that we hear from ACRG about this item when the actual operator has this item as their agenda item coming up next. Or could be consideration of the request for the reconsideration of the board order.
Yeah, and
because if the three items that ACRG is talking about in you know, agreeing about the clarification of the financial warranty, the April 2024 board order about the withdrawing from the life of mine, but asking him to hold the board order in advance to allow them to complete their due diligence. I'm now confused as to where that discussion item and board action happens if the next item on the agenda is Grand Island Resources consideration of the operator's request for reconsideration of a board order.
Yeah, and Madam Chair, that may be a question for a question that might be helpful is how does this narrowed petition
Mhm.
from ACRG different from that particular piece of relief that the operator's requesting?
Yeah.
Um,
In which case, I feel like it's appropriate for the operator to present that information as opposed to this 10-minute presentation that's teed up. If for some reason this 10-minute presentation that's teed up has some other information, we could think about if we need to talk about that as well. But I feel like it's a little bit more appropriate that Grand Island be presenting that information when it comes up to this. So in my opinion, I still think all we're doing right now, even though we appreciate the clarification, is we've still got to decide whether or not we're considering, this petition.
If I may, Madam Chair, with due respect, I do not believe that Grand Island Resources is in any position to present the information that ACRG is going to present. So while the requests and remedies requested are similar, the reality is that what ACRG is going to present will in fact be different from Grand Island Resources, and the rationale for it are different. And perhaps, and I don't want to speak for Grand Island, but their issues are going to be focused on board decisions. Our issue is focused on the perspective, the opportunity to clean the whole process of this particular mine up and get it on a brand new footing with a new operator. So we would respectfully ask for 10 minutes to let the board know what we are planning. And frankly, Madam Chair, that might well inform what you do in the subsequent petition. I'll just throw that out for thought.
Yeah, I mean, I hear what you're saying, and it just still makes me uncomfortable because if I'm looking at this just procedurally from where we sit, we're looking at a permit number with the name of the current operator under that permit number. And I just feel like I'm sure I'm sure it's not convenient for you, and I'm sure it's probably a little bit frustrating, but from just like a very kind of looking back at these things, right? We're already reassessing, wanting to reassess the board order from 2024. I can see how in the short term it might feel like more clarity, but I think in the long term it could still just keep kind of kicking this weird I don't want to call it a mess. It's not, I don't mean it that in a negative way, but hearing from someone who potentially wants to purchase this mine that is not the permit holder doesn't feel like as clean as just kind of going through this in order first. Do you understand what I'm saying?
I do. However, Rule 2.5 clearly provides that any person can submit a petition for declaratory orders. So it does not have to be and isn't required to be a permittee. Certainly ACRG qualifies as any person. And given the general interest of the legislative declaration of the Colorado Mine Land Reclamation Act, which contemplates having economically sound and environmentally protected mines, I think it behooves this board to have an opportunity for ACRG to explain, while they may not be a permittee, they certainly have a legal interest as propounded by the Colorado General Assembly in 1976. So I think it would be helpful to the board to hear that. The board can always not rule on the one portion that we have asked about, the abeyance, but nonetheless, I think it would be helpful.
Madam Chair, Jeff Fugate here on behalf of the division. I don't want to further this discussion, but if you allow me some time to try to reset what I think is the procedural process here as far as standing. I do think the petitions that you all have are a little complicated because they overlap. They raise some issues that are not frequently raised before this board. The way I worked through these when I was working with staff on how to address these is you really do have to compartmentalize the requests here. For the ACRG request, the starting point has to be standing. You know, the legal term, do they have the right to ask for what they're asking for? Staff's position is they do not. They're a prospective purchaser of a mine, which is not an uncommon thing in the mining industry. That alone does not afford somebody the legal right to petition the board to ask for something. That is one of the components of Rule 2.5 declaratory orders. They have to prove that they're impacted or adversely affected or aggrieved, and it has to be an impact that is entitled to legal protection under the Hard Rock Act. What I can glean from the petitions and from talking with Mr. Kinnison is I think the impact here is a risk disclosure to shareholders as they're going through the purchasing of this mine or potential purchase of this mine. That's a private contract. That's a private transaction. That's not something that's entitled to legal protection under the Hard Rock Act. I think where the division objects to the request is that they are asking that something be done or the board take some action to either rescind, vacate, or hold in abeyance a 2-year-old order, that April 2024 order. That's where the division has to object, that ACRG does not have standing, does not have the legal right to make that request. Staff doesn't object to ACRG taking time to present themselves to the board, to introduce themselves to the board. Not sure that the proper mechanism to do that is through declaratory order. I believe public comment or something that doesn't come with a board request or a board action is more appropriate. But as this currently stands, I think we have to start with standing. Does this company have standing to even make the request? The board decides they do have standing, then we can move into the merits of the declaratory order. The division will have a position on that as well. The board determines they do not have standing, then I don't believe that the declaratory order can be considered. So even with the withdrawal of their petition to intervene, that essentially takes with it their request for declaratory order. They have to be granted party status to make any requests of the board. So that's the division's position. Obviously, we're available. I'm available to answer any questions. I do want to note that City and County of Boulder are also in the room today. They filed responses to the petitions in these matters, and so they may also want to be here. But I'm available for any questions the board may have of staff.
Madam Chair, this is Wendy Padilla. I have a question.
Yes.
For the Divisions Council. Can you repeat what criteria a party needs to meet in order to have standing? I think I got it, but you were talking a little bit fast.
Yeah, sorry about that. So Rule 2.5 Hard Rock regulations is any person who is or may be directly and adversely affected or aggrieved and whose interests are entitled to legal protection under the Act may petition the board for declaratory order to terminate controversies or remove uncertainties. So that's kind of the elements or the criteria that need to be met for somebody to be afforded standing or party status and to make the request. And here I'm not sure that all of those elements are checked by ACRG.
Thank you.
Other questions from the board? Just
Another clarification is if ACRG was to purchase this, then they would have party status and could do the same thing. But at this point, they don't have party status.
Potentially, I think, again, Jeff, you get for the division, that's still dealing in somewhat kind of hypotheticals or speculatory nature. Obviously, if they purchase a mine, they have a more direct interest than a potential purchaser. In order to actually become the permittee, they still have to go through the division's succession of operation process. So there's forms, there's division review before they then are made the permittee. And obviously, if they are the permittee of this mine, then they've got that their direct standing. They obviously have legal interests at that point in time. But we're not there yet. I know that ACRG, at least in their filings, indicated that in 2022 is when they first signed the contracts and agreements to potentially purchase SMS, who owns the mine. And so this purchasing process has been in the works for quite some time.
If I might respond.
yes.
Couple things. One, The issue for ACRG, and frankly, Tawana can explain this much better than I can, but I can merely give you an outline of how she would set this out. The issue is that the April 2024 board order issued a life of mine decision, which essentially and actually moved this mine into reclamation. What ACRG wants to purchase, logically, is a mine that is operating. And so the reclamation decision is what's causing issues. I don't want to detail them because I'm not the one to do that. My client is what is causing issues for the acquisition. So what we're asking and what Tawana would be asking and what our final request in the declaratory order asks is for an abeyance, a holding off of the final decision that you made in April 2024. I recognize that procedurally that we're kind of out of order in all of this. I want to step back and add one other thing. Everyone or several of you have mentioned the 2022 issue that they were in position to do some of the acquisition and due diligence. I want to say that's not accurate. And again, Tawana can explain why that's not accurate if you would give her a few moments to do so. And so I guess what I'm saying, if I am in your position, in the division's position, with all respect to the division who have been very, very forthright with us, I would want to try and get an entity in charge of this facility that is willing to spend the money, is willing to put up the bond, is willing to work with the division to move this forward, both economically and environmentally sound. Again, I think Tawana could explain it much better than I can, but those are the highlights of what we think. With regard to standing, I want to be clear that you do not have, Jeff, with all respect, you do not have to be a party to file a declaratory order. Any person can file for a declaratory order. Yes, you have to have some form of standing, and a very narrow reading of that standing is how Jeff is doing it, with all respect, and that's fair. That's what the division should do. But a broader reading, if you look to the legislative declaration of that act, which is the act under which your board was created and under which you are to be operating, it does contemplate that you want to have owners who will be economically sound and will operate these mines environmentally well. So I think there is an argument, whether it's a winner or not, but there is an argument that I'm prepared to make in any court that would allow us to do so, that we do have standing based on that broader reading of the act and not the narrow reading of the rules that this board is operating under. I recognize that this is something well out of your normal course, but I think it would be in the board's interest, again, to hear what ACRG has to say. Thank
So
you.
I have a question for Patrick Lindberg. Where is he? Sorry, I can't see everybody. Mr. Lindberg, just without getting into the next item on the agenda, number 12, which is file M 1977-410, Grand Island Resources, consideration of the operator's request for reconsider of a board order. Is it correct that the reconsideration of the board order is the April 2024 life of mine that they want to reconsider?
I believe so, yes.
Okay.
No,
So-
Madam Chair, I don't believe that's the order. Again, it's confusing in how it's written. I believe they're asking for reconsideration of the March hearing of this year, which relates to the establishment of the bond.
Okay.
In their petition, they are also asking for either vacature or abeyance of the April 2024 order. But I think their direct request in the reconsideration is the March hearing, the May 26 order, that's the only one that is timely, that can be subject to the
Okay.
reconsideration time period.
Because I'm looking at it and both are mentioned, and I want to make
Correct.
sure that we are that we're not discussing something on item number 11 that is really the operator's responsibility and right to discuss in their own agenda item number 12. And I don't think it's appropriate to make decisions if the board decides to hear any part of this petition that ACRG is the one discussing that piece. Do you see what I'm saying?
I agree. And I obviously, I cannot want to speak on behalf of GIR, who is also here and represented by an attorney. That's some of the confusing nature of the two petitions is they do join each other's requests. And so there is some overlap in dealing with the declaratory order that for the most part relates to the April 24 order and dealing with the reconsideration of the May 2026 order.
But
There
the
is
only,
significant overlap.
yeah, and then the only item that is still left in ACRG's piece of the petition of the declaratory order is they still want to have a discussion about asking the board to hold and hold off on that 2024 life of mine order. So it's almost like we got to redo the timeline here a little bit. And I'm still, I hear what they're saying about the guidelines for a declaratory order, but I am still not quite sure if they are, because they are not the operator or the owner or, have purchased this thing yet, whether they necessarily have standing for us to consider this petition for declaratory order.
Madam Chair, perhaps a way out of the conundrum might be to move for the moment part of your public comments to this moment and allow ACRG to have its say and present to the board in the format of a public comment. And then if you were allow that and set aside for the moment the petition for declaratory order. I'm just trying to find a way. I think we could have completed the presentation by now.
I understand that. Yeah.
So if there were a way for you, Madam Chair, to say, we'll take public comment, an initial public comment right now, then we get that out of the way.
Is there any harm, though, in allowing item number 12 to move forward if that is about the April 2026 board order, to allow that item to happen, because then public comment follows after it, just from an order of the agenda? I mean, we would still need to make a decision to say, hey, we're not necessarily considering this petition. We'd have to make a vote on that and then hear from Grand Island Resources on their issue. And then because it just so happens that this is the last item on the agenda, you're already moving into public comment.
My only thought on that, Madam Chair, and I think, I understand the quandary you feel you're in, is that the abeyance issue is probably more ACRG's issue than it is GIR's issue. It is the abeyance that is important to ACRG to allow it the time and opportunity to go to its sources, its funding, to be able to say that we have an operating mine and we are now in the process of trying to acquire that operating mine, as opposed to going to folks and saying we have a mine that's in reclamation. Now, we recognize that reclamation can be changed, but at the same time, that is the issue. And that issue actually, with all due respect, I think is ahead of the petitions for reconsideration. And I would note, as Jeff has noted, that GIR joined in our petition for, or our request for the abeyance, but they were not the lead on that request.
Madam Chair, this is Wendy Padilla.
Yeah.
Is it appropriate at this time to go into discussion, or would you like to still have questions? Or
Yeah, I think Miss Nelson still has a question from what I can tell, but then, yeah, in a minute.
okay, I'll let Ms. Nelson.
Yeah.
Madam Chair, this is Russ Means. We do have the other parties and stuff here for Boulder in that. I don't know whether they won't have anything to say or not, but they are sitting here and stuff for that, and they should be allowed at least the opportunity and stuff for that to speak and stuff if they have. If
Yes.
they want to.
I agree. I guess I was still in the do we even as a board consider this petition step here, and some folks choose to just continue providing information without other people getting a chance to talk. So I'm still listening to the board to say whether or not we are considering this. Ms. Nelson.
Mixed emotions here, right? I think there's my concern is, are we going through a proper process? If there's going to be a new operator coming into this, and looking at their website, it's very forward looking, as websites are, that already talks about this asset with a operating permit. So there's very forward looking statements on ACRG's website, and to realign this 24 order to be able to, for them to raise the money to purchase this thing doesn't set necessarily well, right? Just looking at this, it's alarming. So I'm really concerned about proper process if we're going to have a new operator coming over with all these legacy issues, which simply are legacy. They got to be worked through in a manner that, she could put out a presentation that's very appealing, but it still has to go through the proper order, doesn't it? Through staff review and all this other stuff like anybody else.
Yes, I agree.
So that's where I'm extremely torn.
Yeah. Ms. Tarrant?
To continue on with that discussion, first and foremost, my concern about this is that we, as a board, if we hear from ACRG, first and foremost, we have no guarantee that they are actually going to proceed forward. So we have to speak about this from the perspective that it is still an operator perspective, an operator issue. I do think that this is putting the cart before the horse. That said, I understand that if this company does want to come in and they do have solutions to bring it out of reclamation and back into production, then that should be something that the DNR should be able to review and decide upon. But to say we put full confidence in this company and what they're doing, I don't feel that we have that that position to do that. I think that we need to hear from the operator, and if ACRG does proceed forward with purchasing this operation, they can work with the division staff to come up with a plan to pull it out of reclamation and back into operation.
Thank you.
Well, sir, much more graciously said.
I do, because I know that Boulder is in the room, and I want to give you the opportunity to say something if you'd like to, but if we can keep it within the lens of the fact that the item that we're considering right now for board action is a consideration of a petition to intervene and petition for declaratory order. So if there's a representative from Boulder that wants to help with that conversation, so we're able to frame this decision as to whether or not we're even considering this petition, we'd like to hear from you. And if you could please introduce yourself as well.
Thank you. Madam Chair, my name is Joe Middleton. I'm an attorney hearing on behalf of the city of Boulder. And I guess, we filed an opposition to both petitions from ACRG and GIR. And our position essentially with respect to ACRG is that they do not have standing. the prospective interest of a third party in acquiring a controlling interest in the parent of the operator is just not an interest that the act is intended to protect, and the act is just not designed to do that. I know Mr. Kinnison articulated the general interest that the act sets forth in the economic viability of an operator. But I would note that 34321022 also states that in considering economic reasonableness, the financial condition of the operator shall not be a factor. So there are some limits on the consideration of that economic balance there. The key considerations in whether or not a party has standing to petition for declaratory relief are really whether or not there is an injury that's protected by the act and whether that injury is concrete and not speculative. And I think both of those items fail here. And imagine if every prospective operator who had expressed an interest in acquiring, prospective third party who expressed an interest in acquiring an operation had standing to petition the board for declaratory relief. I think you can see the problems that might create. And so, again, there's just no interest that's been articulated here. I also think that given the withdrawal of the petition to intervene, I question what exactly remains of ACRG's filing. If there's no standing to intervene, then, why would the board entertain anything else from ACRG's, particularly in the context of a board decision? I agree with the division that their comments are best left for public comment, and I think the public comment should be after decisions are made so that we avoid any prospect of interfering with the decision process or corrupting that process. And, I'm happy to answer any questions from the board on our petition or opposition or arguments otherwise.
Thank you.
And Chair Wareham, my name is Ryan MLRB. I'm an assistant county attorney for Boulder County. And I mean, we spent a lot of time talking this issue, and I don't want to belabor the point, but the county did join in the city of Boulder's opposition for the reasons stated therein. I echo the concerns and sentiments of my colleague here, Mr. Middleton. I would also want to reiterate, I think it's appropriate for Chair Wareham, you've made this point, to focus on whether or not you should even be considering whether or not the board wants to hear the substance of ACRG's request. I don't believe that they have standing to request declaratory orders. They do not have a protected interest under the Mine Land Reclamation Act. And so I think that forecloses the issue right there. And I'll also say, I don't believe it would be appropriate under the rules and for a good record for the board to move public comment up in advance of considering whether or not GIR's independent requests, considering those. I think that would be an inappropriate decision.
Thank you. Okay, so yes, Ms. Padilla, I believe you had a question on the table as to whether there was any more discussion. I think we've heard a significant amount of discussion. I'm going to ask the question again as to if the board is even willing to consider this petition.
Thank you, Madam Chair. Just in my discussion, I don't see evidence of standing, and I don't think the board should be ruling on this order.
I concur.
Okay. Mr. Koyman, is that something that we should be putting in a motion in terms of whether or not we're considering this petition?
Yeah, I think that'd be a clean way to do it.
Okay, so I'm closing discussion on this item, and I would like to ask for a formal motion on item number 11.
Madam Chair, I move that the board does not rule on item 11.
Okay, we have a second?
Second.
Second. Any discussion?
I second it.
Okay. Any discussion? Okay, all those in favor, please signify by saying aye.
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 Any opposed, same sign? Okay, hearing none, we will not be considering the petition to intervene and petition for a declaratory order. if everyone is okay, tell me, do we need a 10-minute break or do we want to keep cruising here?
Madam Chair, we do wish to reserve time in the public comment period.
Yep, there will be a public comment period and we will talk about that framework and timing when we get to that item, but maybe opportunity for those parties that wish to present something to have about 5 minutes each to present something. So that includes if the city of Boulder has more they need to talk about that's not related to it, or if Grand Island Resources has anything. But the question is, do you all need 10 minutes between items, or do you want to keep on going here?
Chair, if we could have 10 minutes, because a few things have changed, that would be appreciated.
10-minute, come back at 10, let's call it 10:30, just to keep it simple. Does that sound good? Okay, we'll come back at 10:30.
Sure that happened. So, let's get a lot of.
Do we generally have most people in the room, or give it another 2 minutes?
Madam Chair, it looks like everybody's mostly in the room at this point.
Okay. So here we are at item number 12. This is file number M-1977-410 for Grand Island Resources LLC. This is the consideration of the operator's request for reconsideration of a board order with Patrick Lindbergh as staff. All of those who intend to be involved in this conversation, do you all swear to tell the truth? Yes.
Where?
Okay. And then just in terms of in the room, yeah, I can see kind of that back line there, but if I missed anybody, just please introduce yourself, and I'm trying to keep an eye on everyone. So Patrick Lindbergh, do you want to take this one away? Or Jeff Fugate?
Yep, sorry, Jeff Fugate here on behalf of the division. Just to set the table, again, this is a petition for reconsideration filed by the operator, Grand Island Resources. Again, staff here, DRMS is staff to the board. So if you have any questions, whether it's technical or legal, you can be available to answer those. Otherwise, this is GIR's petition, so they will make the presentation after the board has any initial discussions.
Okay, thank you. So Grand Island Resources, are you coming up?
I thank you for your time.
Sure. Hey, just a reminder, since we've got 3 of you kind of in a row, just as you speak, just maybe try to introduce yourself each time, just from a minute's perspective. It makes it easier. So thank you.
Not a problem. Richard Mitesh, Vice President, Grand Island Resources. And I'm very thankful to have a little time to discuss our thing. I have a couple of witnesses I will call that will be testifying on our behalf. What we're looking to do is reconsideration, looking for put the order in abeyance while we completed an acquisition. The acquisition has been simplified as an asset acquisition. That was an 8K that was filed recently, and you could easily find that. We also believe that American Clean Resource Group will do a fantastic job in working with all the stakeholders, working with the board, and working with the division. Grand Island Resources has a good relationship with the people of the division. We feel that all their requests we're more than willing to work with. We also feel that here at Grand Island Resources, we take managing the environment, managing the site, utmost importance. And we're trying to excel in doing it. So while this abatement process is going on, we'll continue to maintain the site in best practices, best environmental standards for all stakeholders. And what I'd like to do is introduce Ben Langenfeld, the author of our documents and our permit writer.
Good morning. My name is Ben Langenfeld. I'm here at the request of Grand Island Resources. Members of the board, today I'm laying out a number of things that I discussed and presented in March of this year. I'm doing this for the purpose of the record, so I do apologize in advance if there's repetition of things you've already heard. When Grand Island Resources first put together the initial application for the DMO conversion in early 2025, our scope was intended to deliberately expand the permit and affected area exclusively for the purpose of enhanced environmental controls and better transparency with the community. We did not pursue this expansion in any effort to rope in unprepared, undocumented, or in any way unreviewed future mining plans. We went into this application expecting to focus on a list of technical details and to deal with a robust public notice period where we knew we would receive a number of objections. It is, after all, Boulder County. When we received the first adequacy review, it contained a number of errors on our part we had to correct, as well as legitimate large-scale technical questions about the existing operation that had not been previously examined in great detail. Answering those questions required additional site data gathering, drilling, sampling, lab analysis, and other work that we had not originally anticipated. We worked diligently to address these items and report back to the division staff. We were able to do so once we received all of the data from labs and other sources in the latter part of summer 2025. In part, it takes this much time due to the high altitude of the site limits the window where any kind of data can be gathered on the ground. When lab data was delayed or drilling operations on site delayed, we realized we needed to continue to get information into the division, and such submitted a partial adequacy response to staff on the items we could address out of respect for their time and the process. Once we had all of the information provided to the division for that adequacy, we waited. In December 2025, we received a second adequacy review. This review identified areas of potential future mining and exploration where the division staff had determined there was insufficient technical data to currently approve it. It had never been our intent to permit those areas for immediate mining or exploration. We had included them out of a sense of transparency and greater environmental responsibility, flagging our long-term plans in advance so that when we gathered the required data, everything would be properly reflected in the permit. Therefore, following a meeting with the staff, we decided to curtail the scope of the application and made it as clear as possible that these future exploration and mining areas would not be pursued until all of the data the division required had been gathered and sufficient designs had been approved by the division. We believe this was a good way of clarifying the intent of our application while still maintaining enhanced environmental protection. The division staff determined that our reduction in scope and our clarification constituted an amendment to the application and instructed us to present this before the board as an amendment request. Staff informed us that the clarifications we had provided necessitated new public notice. Understanding this and desiring a thorough process, we agreed to request an amendment and presented everything to this board in March 2026. During that board hearing, the board decided to reject our request for the amendment while also imposing on Grand Island Resources additional bond. That additional bond was not something we had been notified of in advance of the hearing that it would be on the docket, and thus had not had time to review it or object to the proposal. I also want to be very clear on a certain point. That additional bond that was imposed upon us was a bond we proposed and calculated as part of that second adequacy review response. The very second adequacy review response that this board blocked from being reviewed as an amendment was the source of the bond calculation that we were then required to post. This is reflected in the board order. Grand Island Resources did not object to the additional bond when staff presented it, as we believed it was tied to the amendment request. I will close by noting that I agree that the application is not particularly complex from a technical standpoint. The complexity of it emerges from the scrutiny inherent to Boulder County and the number of public objections. The division appropriately designated this as a complex application, which is standard practice, in my experience, when the division receives a significant number of public objections to an application. A conversion application also operates under slightly different constraints than a new mine application. You are building on existing permit actions and existing timelines. That inherently means some things emerge through the process rather than being fully defined up front. Grand Island Resources has worked diligently and sincerely to put in place the required DMO conversion. Prior to ever assembling the conversion or presenting it to the division, and during the entire time they were appealing the DMO decision, Grand Island Resources was gathering the data and conducting operations on the ground as if they were a DMO. It has included forthright and sincere efforts before this board to continue pursuing the conversion at great direct cost to Grand Island Resources to hold in place a quality, well-designed, environmentally protecting mining operation near Netherland, Colorado. Thank you for your time.
I'd like to call John Henderson as a witness.
I'm John Henderson. I am one of the attorneys for Grand Island Resources. I began working with this operation upon being sworn into the bar in 1978 when Hendricks Mining Company originally controlled the property. For many years, this operation was regarded as a model small mining operation with excellent housekeeping and miner-like practices on the site, and was regarded as a pioneer in the field of passive water treatment. There is no acid drainage in this district. The water is alkaline. As Rich testified, pH is 7.4. What I'm getting at is this operation has had an excellent reputation across the years. In this particular case, I'm trying to keep the board from making a terrible mistake by continuing some of the things that were decided in the last hearing and the hearing in 2024. I reviewed the informal transcript of our last hearing here. There are something like a dozen references at least to a 4-year-long permitting process, and that somehow GIR was slow walking this permitting process. This has not been a 4-year permitting process. GIR, as noted, when after 26 years after the statute was passed, was told you're now a DMO. GIR had a good faith belief that it was not a DMO, that it was not using cyanide or other caustic reagents. It had not yet established milling on site. There was no acid mine drainage in the district. So GIR exercised its due process rights under the Administrative Procedures Act and the Hard Rock Rules, which is to appeal the new DMO status. They ultimately acceded on that, but GIR cannot be punished for exercising its due process rights. The board did establish a deadline for the submission of the DMO application, and GIR met that deadline and filed before that. That GIR could control. All extensions prior to that had been approved by the board. We were exercising our due process rights. We had done nothing wrong, should not be treated as wrongdoer. So when the application was filed in December of 25, it was timely. And since that time, in reality, we've only had about 6 or 7 months of processing time on that application. I'm not blaming staff. This is simply the timeline and the result of massive public comments. We got our completeness letter in early February and then had to wait for official publication to take place and public notice procedures to take place. And then in May, after having received 427 public comments, we got our adequacy review from division. I'm not blaming staff, but there was nothing we could do between getting that completeness letter and when we had to begin responding to public comments. I've endorsed as an exhibit a piece of paper called Division's Preliminary Adequacy Review Conversion Application CN1 dated May 13th, 2025. This was prepared by Ben, who just testified before you. Within days of receiving the first 124 items from division, a lot of requests, and Ben would tell you that probably 70 or 80% of those were relatively routine or clarifications. The others much more difficult. But within days, Ben had constructed a table with each of the 124 response tasks and assigned individual responsibility for the people who are going to be preparing responses. And in some cases, those responses required drilling, engineering or engineering sign-off and field work, which was not routine and not a clarification. This is to be expected. But by then, we were already almost 5 or 6 months into the period after the permit had been filed, and we're still responding to first adequacy. Now, as a practical matter, let me tell you what happens, at least my opinion, what happens inside a division when you get that much public comment. And here we've got scrutiny. We've got institutional comment from the County of Boulder and the city, major institutions in Boulder County, who, as I noted in my last testimony, never before objected to this operation in the 52 years It's been going since 1974. When you have attorneys for the city, attorneys for the county, experts for the city and county, and attorneys for environmental groups that are leading the opposition, organized opposition to the permit request, it is my experience that division has to take a more cautious approach. And that cautious approach is, it is always easier to ask for more information or more work than it is to solve a problem or to agree on a solution on an action item. So when we made our adequacy responses, we got back 106 new adequacy responses in, I believe, December of 2025. A lot of this information was not simply clarifying the prior matters, but the introduction of new materials. It was at that point, upon discussion with divisions, that Ben and the management at GIR felt that division wanted us to simplify the application. Let me tell you one of the reasons for that. And it has to do with things like hydrologic balance. When we are looking forward to the new application, we were putting out a 50-year real mine life. When you start talking about what you're going to encounter 20, 30, or 40 years ahead of you, there's a very, very limited amount of technical information that's available and in front of you. That's why a lot of hard rock mines often have only 3 to 5 years of resources immediately ahead of them. To gather data and to predict by computer modeling or otherwise what you're going to encounter 10, 20, 30 years in the future is very difficult, very expensive. Thus, we were urged to reduce the scope of the application, in this case, from 208 acres to 85 acres. In other words, a 60% reduction. In that 85, as proposed, not in an amendment, but in our adequacy comments in January, there are things in that 85 acres that division was telling us they wanted us including in the permit area above and beyond the 9.9 acres. So we're responding to division. We're trying to respond in a timely manner. So having received another 106 adequacy comments, we suggested truncating and shrinking this application essentially. So we only have 5 years ahead of us, which was doable technically, and we have much more density of technical information on this reduced application. It was division that considered that an amendment. And as such, they stopped processing the application. So in reality, from the time the board gave us to file this application, we've only had 6 or 7 months of processing where we could actively respond to division's inquiries. It has not been 4 years. It has been a year, and a lot of that we were stopped or there's nothing we could do. This mine is not at the end of its life under normal circumstances. It has not exhausted the mineral resources. The company estimates that currently the immediate area resources alone are worth $2,053,828,612 at current prices of resources that are measured, indicated, and inferred. And the prior mining on the site barely scraped the surface of this. Now, of course, ore is only ore if you can mine it at a profit. And even in a small mine like this, if built out to include a mill and further underground operations, you're talking tens of millions of dollars. But millions, many millions have already been invested in this property. These are major physical structures at both the Caribou and Cross sites, which are simply across the creek from each other. And final reclamation is not a benign term. Final reclamation is a benign term only if the mine has reached the end of its ore life and there's no future for mining there, that they've done their job, the minerals are gone. In this particular case, I refer to it as the death sentence, because what it requires is dynamiting, jackhammering, and bulldozing your existing facilities that you've spent 50 years building, then contouring the land and planting it pursuant to the reclamation plan. Why are we receiving the death sentence? I think there was an impression by the board, based on the discussion I saw in the informal transcript, that we've been slow walking this for 4 years. That isn't the case. The DMO challenge was completely within the due process rights and within the good faith parameters of GIR. This is something that they had a legitimate good faith belief that they weren't a DMO. However, there's a sentence in the board's order from the last hearing. All corrective actions have been taken. And there are no outstanding corrective actions. In other words, when this mine went to active treatment, we took those part per million, part per billion aquatic life standards and began to consistently meet them. There is no crises, water quality or otherwise at the site. The site is in compliance and there's no basis for assessing the death penalty. And this is something that the board had a chance to correct in the last hearing, but it felt duty bound to continue and say either if the application is withdrawn or if it was not approved by division, then the mine would have to go to final reclamation. That is destruction of millions of dollars in mine facilities and 52 years of effort. There's nothing to justify that kind of remedy when there's so many other alternatives available to the board and to division. It's not necessary to do that. I want to emphasize one other thing that Ben mentioned. I think that the board is hugely vulnerable in the way that it assessed the bond increase in this case. Normally, in normal due process, division is considering a bond increase. It may or may not notify the operator that's considering a bond increase, but they will issue a letter that then makes a demand on the bond increase for the new amount and generally some explanation of why. At that point, the applicant has 60 days to respond. And what often happens is they can talk with division, achieve and receive their detailed calculations of the bond increase, can counter those with other information. And if they're still dissatisfied with the number assessed by division, they can appeal to the board. What was done last time by assessing that bond increase without notice, without it being on the agenda, and only sending the notification letter several weeks after the board met, and not giving us a chance to endorse witnesses and exhibits, which we would normally do if we were challenging a bond increase and have the full right to do, it was an ambush. And that's not the way the procedure for the assessment of the bond normally works. It's not the normal procedure, and it deprived us of our due process rights. I wanted to make those points because I'm not sure the board fully understood what was happening here. And we wanted a chance to present that information and to demonstrate that this operation, having been a model in the past, has been a model operation for small miners throughout Colorado, was a model for other operations for its water treatment methods and taking passive treatment technology as far as it could go before having to install a much more expensive active treatment. We've had to go there. We've had to go there. And we've performed, as the order noted, all corrective actions have been taken. The board should consider the way it assessed the bond increase. The board should further consider vacating the order, ordering the mine into reclamation. The ideal thing to do here is to send this back to division based on the amended, the suggestion for reduction, which the division considers an amendment of the size of this. Now you ask, what about the inconvenience here? I've testified that we've never had organized opposition to the mine. This is the first time that City of Boulder and Boulder County, many of which we've worked with in the past, particularly the county, have appeared to oppose the mine. Why are they asking for the death penalty? I don't know. Our statute calls for a balance between the environment and mining. In this particular case, we've got 52 years of effort. We've got, Rich, how many feet of drilling do we have so far?
287 feet, 287,000 feet, sorry.
Many, many millions spent on drilling to outline the deposit. And City of Boulder and Boulder County have either prepared reports or written lengthy comment letters. With the reduction in the operation, we lose our entire operation under the death penalty, or all they would have to do is review their existing letters and comments to make sure they were still applicable to the reduced footprint of the operation. Where's the balance? Where to face the death sentence, the destruction of millions of dollars in facilities, the destruction of 52 years worth of work, or the two government entities can re-review their letters to see if they're still applicable and whether they're still objections or objectors. And that's simple enough to do. So to achieve balance, we have way too much on the line. Too many lifetimes of work, including Tom Hendricks. I won't even count myself, but I helped Tom Hendricks, who of course 35 years, assemble the property position of 129 patented properties. And I was fully aware of all efforts to comply with water quality standards, having received from Tom monthly the lab reporting and the reports we filed with the Colorado Department of Health on water quality matters. So I've watched this develop, and the operation has finally had to come to grips with the fact that the microsediments in our waters, which are microsediments, have to be handled by active treatment, and we have done that successfully. There's no reason to administer the death sentence, and the board should reconsider the bond increase, which was not done in accord with the rules, the law, or normal procedures. Thank you for hearing me.
Yeah, Mr. Henderson, can I ask you just a question?
Sure.
Can you please clarify, and again, based on what the conversation we just had with the previous item, which when I asked those questions was just about discussion or reconsideration of the financial warranty. Are you also asking to reconsider the life of mine? Because I'm getting
absolutely.
Okay, so I'm getting different information than was in the conversation before. When I asked this
the operator
for item number 11, it was my understanding that this request for reconsideration of the board order was related to the financial warranty.
No, our request for reconsideration includes reconsideration of the life of mine and the assessment of the death penalty. That relates in two ways.
Let's not use the word death penalty here, because this is a citizen board here, and as is all staff in the state of Colorado, we're working to make sure that we're being good stewards of mines, whether they are active or whatever their status is. And, you know, even if a life of mine is determined and you're, you know, put into reclamation, you have 5 years to work on that process, right? Which is still time in this unique situation where you can get your ducks in a row, work on things like succession of operators. So I don't know that it's necessarily quite the right way to frame up that use of the word.
May I continue my answer concerning the order being appealed? We are appealing certainly the most recent order that was finalized on May the 13th. In that order, this board decided to continue and to follow what it believed was its position in the April 2024 order, which called for end of life of mine. And as such, they had a chance to correct that, because what they were doing when they made that determination in April 2024, they were pre-adjudicating a remedy based on facts and circumstances that had not yet occurred. And I think that procedure is legally defective, and they properly should have reconsidered that. And whether it was appropriate, still appropriate under the existing facts and circumstances presented, including the fact that this was not a 4-year permit proceeding, should have reconsidered that in the March 18th meeting where the final order was ultimately issued on May 13th. So yes, we are definitely asking for reconsideration of that order on both points.
Ms. Tarrant, you have a question?
Yes, thank you. This is directed at the division staff if they are available. It's about clarification of the surety that's in question right now. It was my understanding in the March proceeding that the surety was based on the long-term water treatment, the post-mining water treatment, and was not necessarily tied to the acreage itself. Can you please correct my understanding or elaborate on what the surety was based on?
This is Deputy for the division. We'll have some presentation rebuttal after JR is completed. We'll field those questions specifically about the bond at that time, if that's okay.
Okay, thank you.
Providing answers out of order.
Okay.
Well, I'm sorry. If possible, I'd like to call my next witness.
Well, I had a comment on the question about the surety, because it does require clarification. That number was pulled out of one of our adequacy responses to the second adequacy response, which would have been the one we submitted in early January of 2026. That is the amendment that the board did not allow to go forward. Now, there was testimony that our water quality treatment costs had decreased as we found we could recycle materials, and the bond increase also contains bonding for facilities and structures that are within the 85 acres, but are not within our current permit of 9.9 acres. So that figure was not developed by division. In normal course, division develops detailed figures based on regional and other construction cost estimates, which they assemble and which are generally available to the applicant to examine when a bond increase is requested. That was not done, and that was part of the problem with how rapidly this happened. Rich testified he had 15 minutes notice of a $1.6 million bond increase. That's not the way this normally works. We've normally got 60 days to work with the division on those figures, to look at their estimates, and if we wish to counter them with what we believe the true costs are. And then if we're dissatisfied, we could go to the board and appeal it. That's the way it normally works. We don't get ambushed at a board meeting on a tiny procedural issue. And the procedural issue before the last board was, were they suggesting an amendment? And should we allow the amendment to go forward? Because the time for public notice and publication of an amendment would take it beyond the April deadline established in the 2024 order, which that would have been the logical way to proceed under the facts and circumstances. And we could continue to process the reduced application in a logical fashion and in accord with the rules. That was my answer.
Okay.
I'd like to call my next witness, Tawana Bank.
Just 1 minute here. I typically, when I tee these up, I have some kind of understanding of who we have talking. I mean, I'm looking at the agenda, I'm looking at the board packet, and you know, normally I would have had some understanding of who was presenting from Grand Island Resources, how long Grand Island Resources was presenting. If the city and county of Boulder would like to speak, I expect that we will hear from the division, how long those presentations are. If there's rebuttal, who has, you know, kind of some things that we can't just sit here and have presentations and witnesses called from Grand Island Resources for an extended amount of time. So can you tell me how much more information you intend to present and how long that will take?
No more than another 5 minutes.
Okay,
And then we can get on with it.
Okay, and then what I'm going to do.
I apologize for not having all that information in advance.
Yeah.
And of course, we want to make sure that the decisions here are made in the best order and most informed. So thank you for giving us that opportunity.
The best way for you to get the board to understand what is happening is to come with a concise order of a presentation and help us understand. So for me to ask halfway through, what you're asking us to reconsider is, you know, not clarity. So we'll go 5 more minutes with Grand Island Resources, and then I'm looking at Mr. Fugate here. Do you think it's appropriate that we ask if the city and county of Boulder have anything to say, or at that point would the division like to have some clarification and rebuttal on Grand Island here?
If possible, I imagine the division won't need more than 10 minutes of presentation and just be available for any questions from the board. And then if Boulder, when Boulder can then present, I'm not sure how much time they'll need, but also for them the same opportunity to provide some testimony for rebuttal.
Okay, so Grand Island Resources has about 5 more minutes. Division's going to come up and just have a bit of a presentation for 10 minutes, and then Boulder, sorry, you're off my screen right now, but do you folks need a little bit of time to chat too? I'll just have Jeff.
Yes, Madam Chair, could you have 10 minutes?
Okay.
Yeah, Madam Chair, this is Ryan Miller from Boulder County. Just to be clear, Boulder County is here independent from City of Boulder. We join the same position, but we are 2 separate entities. Then, I mean, I would reserve 5 minutes. Any questions?
Okay. 5 for the city, 5 for the county. If one of you concedes some time, you guys will figure that out. And then, you know, couple minutes on rebuttal as needed for each. 2 minutes, I'll circle back over to Grand Island Resources, circle back over to the division. Or actually, probably I'll circle back over to Boulder and then I'll have the division finish it out. Does that sound fair?
Yes.
I would have used my 15-minute break differently had I known this was what we had in front of us. Okay, 5 minutes.
Good afternoon, everyone. I know this is a bit unprecedented, but thank you for allowing me the time, Madam Chair. The first thing that I'd like to do is just to introduce myself. You've heard the name, but I think it's important to also understand a bit about my background and what it is that we're looking to accomplish.
Can I just ask a clarifying question, because the attorney for American Clean Resources also wanted to pull you up for a presentation. So are you representing American Clean Resources, or are you speaking on behalf of Grand Island? Because your attorney said that you had a better presentation than Grand Island did on the financial warranty, and we were reserving that for public comment.
I am representing American Clean Resources Group, and during the break, because some of the information GIR felt was important for the board, asked me to testify here on their behalf.
I'm just really confused here because normally I have a much more concise order of things here. So I'm not sure that I'm comfortable with you just coming over and presenting something that we just had a big conversation about in being presented in public comment. You're presenting the information that we asked you to present in public comment now?
No, I do intend to still speak during public comment.
Mr. Fugate, thoughts?
Thank you, Madam Chair. Apologies for you appearing on screen. The TVs are over there, the camera's in front.
It's
so
fine, I
can decide
understand.
views. It's an odd room to testify in
Yeah.
hybrid. I think I share your concern that I'm not quite sure procedurally what is going on with this particular testimony. I don't know the division necessarily objects so long as it's relevant to the actual petition for reconsideration. As part of the division's presentation, obviously we'll take some issues with what is subject to reconsideration and what is, in our opinion, time barred. But at this point, I don't object to the testimony so long as it's relevant to the reconsideration request.
Okay, so we can do that. I just want to make sure that we, the conversation is about lines getting blurred, facts, things like that. And so, I just do want some offer of proof that what you're testifying about is relevant to the two matters at hand, the April 2024 life of mine and the March 2026 financial warranty. Is that correct?
That is correct, Madam Chair.
For 5 minutes or less?
Raising money is crucial. We need to be on that pressure.
I yield to you and will accept moving forward once you grant it.
Okay, please proceed.
Thank you. So there's several things as it relates to the life of mine, as well as the financial warranty. Obviously, if ACRG is going to post that financial warranty, we want to understand how that warranty was calculated. And I have a fiduciary responsibility, obviously, to our shareholders if we're going to post that type of bond on behalf of an acquisition right now that looks like it might be in trouble. And so I think it's really important that we all here as community leaders ensure that if the acquisition is something that you all would like to see proceed here in this community, that ACRG has provided that information. As it relates to life of mine, there's a number of things I think that have transpired over the course of the hearings. And the reality is this. As the CEO of ACRG, and well as the chairwoman, I am hard pressed to convince any shareholder or institutional investor that we can raise money for something that we don't have a permit for. Yes, I can talk about what we could potentially do by getting it out of reclamation, but that makes that extremely difficult. And so I would definitely endorse what I'm hearing from John Henderson as it relates to it potentially being the death penalty. What you have before you is a potential successor. And while, yes, there was a definitive agreement that was entered into with ACRG and GAR back in 2022, I did not become chairwoman and CEO until 2023. And at the late 2023. So I can't speak to the reasons in which this operation did not proceed with its close prior to my leadership. But during that time, there were a number of things that had to get done as the new chairwoman and CEO to be a responsible operator. And before bringing another company under our roof, we needed to get our house in order first. And so as it relates to us proceeding, what we're asking for is for time. The abeyance that GAR is asking for will allow ACRG to now proceed with an asset acquisition as opposed to a company acquisition, which was what my predecessor had entered into. That asset acquisition allows us to get a fair opinion rendered on the valuation of what this mine is worth. Obviously, a lot of this conversation makes it sticky alone. And it also allows us to properly transfer the application as well as the permit over to ACRG. And then one thing that I think is just extremely important, because I think at the end of the day, there's two things that are extremely important. Our ability economically to step in, and where do we stand as an environmental steward of this? And so as you consider both the petitions, the financial warranty and the end of life, obviously whoever's going to be the successor matters. I spent my career in the space of water. I worked right under Dave Roskin, who is the world-renowned hydrologist and geomorphologist that designed the natural channel design for how geomorphologists should restore impacted streams. I advocated for every federal agency and state agency to institute river morph in their operations when it came to stream impairment. You can't find a better person who will ensure that not only we are mining and bringing jobs and economic vitality here to your community, but someone who is going to preserve the waterways here. And so as we think about an off-ramp, you have the second conversation around economics. And I do recognize that the county and the city did cherry pick our filings. But if they would have given you all of the facts, since I stepped in as CEO and chairwoman since 2023, they would have told you that there's a woman that came in and cleaned house. She upgraded her securities council. She upgraded her financial team. She brought in a new CFO. She brought in new auditors, because that's discipline, not rushing a hasty decision simply because there was a transaction on the table that predated me. And that's the same discipline that you all will see in my leadership if we're afforded the opportunity for the abeyance to get a proper valuation. I do have fiduciary responsibilities to the United States Securities and Exchange Commission, and doing anything hastily can only land me in somebody else's hearing. Thank you.
Thank you. We appreciate your time. And we look forward to working with you guys. And we will keep good steward of the land.
Just for introductions, I'm Jeff Fugate, attorney for the division. With me here,
Jared Ebert with the division.
Patrick Lindbergh with the division.
so where I'm going to start, and I'll try to be as efficient with our time as I can be. I'd like to field any questions that the board may have, either legal questions or interpretation of the rules, or any of the technical questions that may have been raised. What I do want to make sure is that the board recognizes the narrow scope of this request. I mean, it's a request for reconsideration. I do appreciate Madam Chair's questions about clarifying exactly what they're asking to be reconsidered here. I want to start with the criteria in Rule 2.9. What's the process that we're following here? Under 2.9.1 subsection 2, a petition for reconsideration has to set forth a clear and thorough explanation of the grounds justifying reconsideration and must include new and relevant facts that were not known at the time of the hearing. That's important here because I'm not sure that anything that was discussed by GIR is new or that was not known at the time of the March hearing and the May 2026 order. They're presenting it as though it all just happened just in the last few months, and that's not the case. So what they seem to be asking for in the request for reconsideration is that the board reconsider an order from April 2024 that deals with the life of mine. So they're asking the board to reconsider a 2+ year-old order. Seems like they're also asking that the board reconsider or change the position on a January 2026 decision by the division that the significant changes to their application amounted to an amendment to that application. And then finally, they're addressing the May 2026 order as it relates to the financial warranty. So all of the things that they touched on in their petition and raised in their presentation today, the only one that is timely under our reconsideration rules, it's a 20-day time period in which they can file a reconsideration, is that May 2026 order. They're 2+ years late to request the board to reconsider anything related to the April 2024 order. Particularly that order, that hearing that led to that April 24 order, GIR was a party to that hearing. They were here with counsel. They did not seek reconsideration at any point in 2024, and they did not appeal that order. So it became a final order of the board in 2024. What they cannot do is, at this point in time, reach back 2+ years and ask the board to reconsider that. Just because that order was mentioned in the May 2026 order does not somehow revive that order and subject it to new requests for reconsideration or potentially judicial review actions. That 2024 order is final, and that sets the status or the current situation of the mine. So what I want to focus on is what is timely under this reconsideration request, and that's their discussion about the establishment of the financial warranty. Staff is here to outline the process. What I do want to discuss is that it is within this board's authority to establish a financial warranty during the course of a board hearing. So I'm not going to take any position as to whether or not the way that the board established that bond was correct or incorrect. I believe that there is support in the record to justify that bond. What the board is willing, or what the division is willing to do here, is concede that if the board wants to provide for, a reset of that financial warranty that follows the statutory and regulatory process, staff can do that. If the board directs staff to issue a new notice of surety increase, provide time for staff to engage with GIR to negotiate whether or not the staff's bond calculation is something that GIR can accept, or if they want to negotiate, tweak with it, we can create that time period, which will eventually lead into the surety increase process that's outlined under the statute and the act, where they will have 30 days to post that financial warranty. Staff has looked at the current conditions of the site, the current approved permits, and have prepared a bond calculation that they are prepared to send to GIR to kind of reset the clock on that bond calculation, bond amount. The remainder of their requests to set aside the 2024 order or hold it in abeyance, that is an untimely request. The division opposes any or taking any action on resetting that 2024 order. So before I hand it over to division, any questions on either the legal process here or the division's position on their requests?
That was really helpful clarification, at least for me, Mr. Fugate. Thank you.
I have one question. So in regard to the April 2024 order, so at one point, Ms. Chairman, you mentioned that they have 5 years to perform reclamation. What is the timeline from which that 5-year period started? Was that the April 2024 order, or was it more recent? I'm just trying to get my timelines organized.
Would be the May signed board order of 2026.
Okay, so that 5-year period for reclamation would realistically start last month.
Yes.
Okay, gotcha. Thank you.
Mr. Fugate, I don't want to jump ahead too much, but kind of where you were leading was a bit where my head was going as well. And at the same time, I want to be respectful of the fact that the city and county of Boulder has, taken time out of their day to be here and be present. So I don't want to not give them an opportunity to speak, but maybe just kind of putting this idea out here, you put it in much better framework than I was thinking. I was just thinking about if we needed to just continue this, but maybe is it just a comeback with a little bit of what you outlined for the process in which staff would work with GIR to work through this financial warranty, instead of it being on the table as a board, motion to reconsider. Can we maybe just make it a different item? And I'm guessing it still needs to come through the board because of these reconsiderations, but is that something where maybe we give it a month to work through some of those things and come back to the board? But again, I want to be really thoughtful about others in the room. And I mean, this is not here on my agenda as a formal public hearing. This is, a board action. And so I don't want to muddy those two processes here, even though sort of calling witnesses and having deliberation and having all those things is making it feel a little bit more like a formal public hearing. And I'm trying to avoid that, but I'm also trying to avoid making it so that people who are in the room are not heard. So that's kind of where I'm stuck right now.
Sure, and I appreciate that. I do recognize we're trying to thread a needle in a somewhat messy process. I do think that under the request for reconsideration, they have raised or taken issue with how the board established the bond in the May 2026 order. What staff is offering up is to allow the board to take action on that particular part of the reconsideration by directing the staff to issue or follow the statutory and regulatory process for a surety increase. Jared and Patrick can probably better outline what that process looks like as far as behind the scenes. Mr. Henderson also outlined, the more typical process of establishing a bond that doesn't, typically won't involve a board hearing or any kind of contested matter. But some of that is getting it back into just the more familiar process for the division and the operators, just as it relates to the bond here.
Okay.
Yeah, just in terms of the process, as Mr. Fugate discussed, we have prepared a cost estimate using our software that we are prepared to provide that estimate to Grand Island Resources. Our typical process when we do that is we give them 2 weeks to maybe 30 days to review that, and then we can go back and forth with them on that estimate, and we usually then come to an agreement on that amount. And then the division staff will issue a formal notice of surety increase, and then that triggers the 60-day deadline to submit the required financial warranty. So we are prepared to pursue that should the board desire us to initiate that.
And again, we recognize, as you have, Madam Chair, that City and County of Boulder are a party to this matter. They will also be provided with the division's bond calculation. Because we're not sure what direction it will go, there is a possibility that we can reach agreement on a bond with GIR and potentially Boulder, move forward with that bond amount. If there is a dispute and if we're not able to resolve that dispute, then again, the regulatory process contemplates issuance of a formal surety increase notice that triggers either an appeal right and or an enforcement action if they fail to post that bond. The hope is we won't get there, that we'll engage with the operator and City and County of Boulder to reach an amount of bond that covers the outstanding liabilities, reflects current site conditions, and is an amount that GIR can post, or in the event they are purchased or acquired, that ACRG can post.
What was the amount of the original bond?
The bond that was established in May of 26, it was a total bond of about $2.15 million. That's a $1.6 million increase.
And then what was the new bond?
The new bond, and again, we've not shared those numbers publicly, but it's in that range.
Excuse me?
It's in that $2.1 million range as well.
So then there was no increase?
There's no increase over the board ordered amount in March, but it will amount
What
to
was, what was the original bond
the
before?
current bond was
$546,000.
$546,000. So the
So-
board ordered increase is about $1.6 million of additional bond.
They went from 500 to 2.1.
Correct.
And so what Mr. Fugate is putting forth here is some of the concern is maybe how that came about in the hearing, not so much, you know, and so kind of going back on the process a bit, going through it, working with the operator, allowing City of Boulder, County of Boulder to, you know, see it. Again, you know, for the board, we don't see every single surety increase come before us. We see it either when it's not posted in a timely manner, you know, when there's kind of some discussion happening, but you know, this is something that the staff works on, you know, with operators all the time, you know, in their normal day. We just see it when it does need to come in front of the board or when it just doesn't get posted in a timely thing. So, you know, that's something that's, you know, on the table here for now. And from my perspective, I'll just say, I feel like it feels like a little bit of a cleaner path. But I would like, because the City of Boulder is here, County of Boulder is here, I would maybe just like to give them 5 minutes because that's what we agreed upon. And they have taken time out of their day to be here just to make sure that we're not thinking we're doing something that doesn't make sense for folks in the room. So if that's okay, Jeff, if that's okay, if they come up now.
Yeah, absolutely. I just want to make sure if there's any other questions.
Sure.
Yeah. So at the time, the bond was increased to 2.1. Did they protest it?
That happened at the last hearing. So the March hearing, subject to the May, it was established during the hearing itself. So there was no opportunity to protest it. If you recall any, during testimony, there was no formal objection at that time. The objection came in the form of this request for reconsideration.
The concerns that were raised were primarily about timing of submitting a financial warranty.
Okay.
So in regards to that, I would say they did push on that a little bit.
Thank you.
Thank you, Madam Chair, members of the board. Again, I think the division was right to refocus the conversation on what's actually before the board right now. And that is the petition for reconsideration. And to some extent, it's not clear to me, but to some extent, perhaps there's still some request for declaratory relief. So I just want to be clear. The City of Boulder agrees with the division that the time for reconsideration
Could you speak up just a little bit? I'm sorry.
the time for reconsideration of the 2024 order, which is the order that established that the life of the mine would end if the DMO application was not submitted. That time has long since passed. It was not appealed. There was no petition for reconsideration submitted within the time frame. And so I want to keep that first and foremost before the board. I also want to address ACRG's position to some extent. No one is asking ACRG to acquire GIR. No one is asking ACRG to post a bond. That's the operator's responsibility. And while certainly, the public appreciates a bond being posted, a financial warranty that's adequate being posted, I don't think it's the division or the board's place to ensure a third party's business transaction. That's just not why we are here. I think ACRG, if it wants to move forward and acquire the mine, is free to do that, whether there is a permit in place or not. Certainly, I'm sure its investors would appreciate having a permit in place, but that's not a consideration that the board or the division needs to take account of. So again, we're far too late to reconsider that 2024 order. And I think that the consequences of that order, which we saw earlier this year in March, flow naturally from the order itself. There's nothing new that's been presented. There's no new outcome that no one anticipated here. There was a deadline set, and to put it simply, GIR failed to meet that deadline. Whether you consider that to have been 4 years to prepare an application or 2 years to prepare an application, there was plenty of time to prepare an application. And GIR, if it wanted to, could have simply submitted a DMO application addressing the current operations at the mine, establishing environmental protection facilities that would have addressed the current status of the mine, but instead they submitted a very expansive application when they didn't need to, and that complicated the process a great deal. And again, nothing new has been presented that would form the basis for reconsideration. So a couple of other points I want to make before I turn it over to the county. I think the public participation process, it's contrary to ACRG's or GIR's assertion. I think that makes this a better process. I think that the county and the city participating and scrutinizing this application, the result is better all the way around. And so I just want to keep that in front of the board as well. We have an interest, just as GIR does. 2/3 of the city's drinking water supply is downstream of these areas, and that seems to get lost in this conversation. I think, again, there's no reason we need to consider the petition for reconsideration. There's certainly no reason why the board should rescind or otherwise circumscribe its 2024 order. So if you have any questions, I'm glad to address them. Otherwise, I would turn things over to Mr. Miller.
I guess just from a point of clarification, just because they're essentially talking about 2 items, kind of sort of 3. I hear what you're saying about April 2024 life of mine, that side of things. Anything on the financial warranty in terms of March 2026, the process that Mr. Fugate sort of outlined as a maybe potentially kind of arriving at the same place, but through a different, more precise methodology.
Yeah, I think the city does not object to the process Mr. Fugate outlined.
Okay, thank you. Just want to make sure we were on the same page with that. Thanks.
Okay, well, thank you. Ryan MLRB, Boulder County. At the outset, I just want to clarify, any appearance I've made before this board is behalf of Boulder County's Parks and Open Space Department, Public Health Department, Public Works also submitted comments. I just wanted to clarify for the record that if the operator does keep its permit and decide to operate, they may have to go through a land use approval process with our community planning and permitting department, which is not a department I work with and is not represented here. Trying to keep this simple to the extent that there's now a proposal on the table to reevaluate the reclamation bond following the act and the Hard Rock rules. The county does not object to that. We reserve our rights afforded to us under that process, but we don't have a problem with the board granting that relief. We do object to the board reconsidering. Essentially, we are being asked to reconsider the 2024 order. The time for that simply has passed years ago. There's no new information that's been provided to you that would warrant reconsidering that order or reconsidering the May 2026 order. Any information that's been presented to you now should have been and was available to GIR at the time. Arguably, to the extent you've heard any new information, it's essentially from ACRG, who doesn't have any standing in this proceeding, and its business interests or business risk is not protected by the act. and it's not within the jurisdiction of this board. So simply, we would ask that you deny the petition, except for reconsidering the reclamation bond.
So my question, I think both to the city and the county, if the mine was in operation for 52 years and you didn't get involved in this until what, a couple of years ago?
As far as the city is concerned.
When did the city or the county voice opposition to this mine?
Well, keep in mind that the operator of this mine was very different for the previous, 52 years that you're talking about. And the city had a good working relationship with the prior operator of the mine. When GIR's operation resulted in water quality violations, that's when the city, first became very interested. And that was a few years ago. And so
what was that violation?
Well, so I believe it, someone will correct me if I'm wrong about the dates here, but I believe in 2021, there was a collapse in one of the tunnels at the mine, in the Idaho tunnel. That resulted in discharges in an excess of water quality standards. And it resulted in violations issued by the division and corrective action required by the division. And that was what precipitated the designated mining operation decision that the division made in 2022. Now, the city has followed those proceedings all along, and the city has submitted comments when the new application was presented, in 2025. So the city has continued to present comments all along and attend hearings and participate in the process throughout. But, of course, again, the circumstances changed drastically after that tunnel collapse and after the operators changed hands in the 2021-2022 timeframe. So, but the city has, keenly observed and participated in the process all along. So it's not as if we're stepping into this, without having kept an eye on it.
Thank you.
And I'll say on behalf of the county, I can't speak to what the county's position was on this mine 40, 50 years ago. What I can say is that, yes, circumstances change, operators change, county leadership, staffing changes, but our commitment to, for the benefit of county residents, to ensure the environment is well cared for, public health is well cared for, impacts to our county roads are taken into consideration, that we do monitor these kinds of operations, and we felt it necessary to involve ourselves in this process to assert the rights of the county, or the concerns of.
What brought you to involve yourself? What action brought you to involve yourself?
Yes, it was the water quality violations and the potential impacts of future mining on the environment and public health, impacts to water, potential impacts to county-owned open space properties in the vicinity. I would say that is primarily what brought staff, the county, to want to submit comments on this and to, assert our position within these proceedings.
I would just add that the prior operation was roughly 10 acres. And the DMO application submitted in 2025 was over 200 acres. And so that drastically increased the size and potential impacts of the operation and implicated a lot more of the county's land, implicated Forest Service land, and 2 different drainages that feed the city of Boulder's water supply.
Any other discussions or questions for the city of Boulder or the county of Boulder? Okay, thank you.
Thank you for your time.
Yeah. Grand Island Resources, I promised you a bit of a rebuttal. Just can you give us some clarification as to what you're thinking, where you're standing along the lines of, have any new facts been presented in front of this board? We are only discussing the possible request for reconsideration of the board order, which is the March 2026 financial warranty. I think we've established that the other one maybe isn't something that's timely, but would like to hear your thoughts as to whether or not you would like to follow along with what Mr. Fugate has outlined in terms of going back through the process on the financial warranty.
I think that in essence, the division knows that the process used by first proposing a warranty increase at the board meeting without being on the agenda does not follow any of the normal procedures. So I think there has to be a remedy for that. As you know, we are not just questioning the April 2024 board order, because your latest order chose to honor that. What the April 2024 order said was that GIR had to timely file an application for the DMO. It did. But getting quote unquote approval from division is not something we control, nor does GIR control public comment, which suddenly there was an overwhelming organized response where suddenly the local government entities have become involved, including government entities we've worked with before, and multiple citizens and citizen groups as well. We're not here to adjudicate which of those comments were good, bad, and ugly and which weren't. But it forced division to deal with them. And when division has to deal with them, we've got to deal with them. And the clock runs out. We have done nothing wrong. There is no wrongdoing such that the board should enforce the death of the mine. There's no action that has taken place which has shown us to be an egregious violator or a rogue operation such that we should destroy our facilities we've been building for 50 years. I do question, why does the city and the county want the mines gone? County open space is something we've dealt with. They have designs on our several hundred acres of land up there we've assembled. I don't know, but there's no reason for them to want the mine to cease, as that mine has pumped, even during COVID, millions of dollars into the Netherland community. So why do they want the mine gone? Why is the first involvement they've got is to ask the death of the mine that Tom Hendricks and the rest of us built? I don't see a reason for it. I don't see a reason for going back to that April 2024 order when new facts and circumstances came to light, including the fact that we had been in full compliance on water quality matters. And I don't want to have a hearing on water quality. If we're going to do that, we'll get the witnesses and exhibits and do that. But then when we got to the last hearing in March of this year, the order was finally issued on May 13th. We had a chance to consider the facts and circumstances, considering the application and the application being filed, and a very, very large public comment that had to be dealt with first by division, and then they dump it on us. We've got to respond. Time ran out. When we proposed to downscale it, they stopped processing until we could have our March hearing. There's your year. We got 6 or 7 months of processing, not a 4-year permitting period. And the board should reconsider its decision to order the mine closed under those circumstances. We haven't earned it, don't deserve it, no reason to do it.
The only thing I would do is echo Mr. Fugate's advice regarding the bond. The process he's outlined is the typical process that many applications I've worked on, where the staff proposes a bond increase and the applicant has an opportunity to review it and provide clarification, or even in some cases revise methodologies in order to find most cost-effective ways to accomplish the reclamation that should be reflected in the bond. And I think that's a good process to follow.
I might also add, this is Mr. Henderson once again, that Ben has been attempting to engage with the city of Boulder since the time they filed their initial comment letter. And the city, for whatever reason, has been unresponsive to our inquiries to try to work through whatever issues they may have. We do not believe we in any way threaten their water supply. We don't even discharge to North Boulder Creek, where most of that water comes from. But we're going to have water quality hearing. We can do that another time when we can all endorse witnesses and exhibits. But we tried to engage with the city of Boulder with regard to the county. We've twice engaged with Parks and Open Space for land exchanges on our boundaries. And we voluntarily went through the county permitting process at land use in 2008, as I recall. So they're not unfamiliar with us.
Mr.
Rich,
Henderson,
anything else?
Look, I'd like to improve the relationship here. I think we got a great resource that we can get into operations, which is good for everyone. We could do it in a very good, very friendly manner, in a very good environmental manner. We got a new operator coming in that will adhere to the highest, strictest standards that I think the board would really feel proud about. I think we can make a flagship mine here. I just need a little bit of work with you guys and cooperation, and this will be something that we could tout on how successful it is, how much it's doing for the communities, how much it's doing for the county. We don't want to be opposition here. We want to be cooperative with them, and we want to be cooperative with the division. As I said many times, I enjoy the interactions. And when Patrick comes up and says, you should do this way, we immediately make those changes. I don't think there's any suggestion that the division has made that we have not implemented, and we don't take it in the most serious manner possible. Please reconsider. Let's try to make a great property here and a great property for everybody. It will take an investment to do that. And we do need to go to the marketplace to get that investment. And having more dings and bings doesn't help us do that. Thank you for your time. And we enjoy the ability to state our case.
Okay. Same question I asked the city of Boulder and county of Boulder. Do you have any opposition to what Mr. Fugate proposed in going back with division staff to go through the process with the financial warranty increase?
I believe we don't have any opposition to a proper procedural process.
Okay. Sounds good. Does anyone feel like they need any other information presented, division staff, Boulder, Grand Island, before I essentially close testimony? Does anyone on the board have questions for?
Madam Chair,
Yeah.
the attorney for City of Boulder is raising his hand.
Thank you, Madam Chair. Just wanted to make one quick point. The city did interact with Mr. Langenfeld. We had a call with him. They followed up to his requests to discuss the mine. At that point in time, I think matters were still pending before the board and hearings were set. And so, but they did respond to requests for information or to discuss status of the mine. And then I also just wanted to make the point that, the city did cooperate with former operator for over 50 years. And so it's not an issue of mining or cooperation or anything like that. The city has a track record of working with the operator there. I just think that strict compliance and the highest standards, as Mr. Minish noted, require, first of all, compliance with the rules and the submission of the DMO application that meets the standards of the rules. That's first standard of compliance that should be. That's all. Thank you.
Thank you.
Members of the board, I'm at a loss as to whether the city is maintaining that because we appealed the DMO status that division accorded us, that we should somehow be punished for that. We were totally entitled to appeal under the rules and had good reason to. However, we've since conducted ourselves with the standards of a DMO, and we timely submitted the application. That was Mr. Henderson speaking.
Yes, thank you. I mean, that's a question for the city. I'm not sure what your question is related to the question I asked you, which is what's on the table. you're talking about the DMO and all of that application, and you're kind of still talking about like the life of mine pieces of things.
Well, yeah, I certainly am still talking about that.
Yeah.
Because I think our deadline established in the April 2024 order for termination of life of mine, when the mine plainly already had a permit or a legacy permit, was an artificial deadline because we can control when we submit an application. We cannot control division's ultimate approval. We cannot control how many questions division asks. And we cannot control public comment, which was organized opposition. We got 427 comments.
Some were good.
Pardon?
Some of them were good.
Some of them were good and some of them were off the wall. And, you know, division has to deal with them and then we need to deal with them. And so I don't know what in that set of circumstances indicates that in the order that it issued after our meeting in March 18th, 2026, order final May 13th, that the board found termination of the life of mine appropriate, having not secured division approval. And we demonstrated just now with the timeline, we've got a total of 6 or 7 months of processing. Why are we bulldozing the mine? I fail to see the connection or the balance that's required in the statutory scheme there.
Okay, so it sounds like we don't have any more discussion about whether or not we want to proceed with the division's recommendation to, and we'll put this in a much more eloquent manner once I get my wording straight, but to go through the process of, you know, the financial warranty calculation.
It should go through the normal process, Mr. Henderson. Yeah.
Sounds great. Thank you. So I'm going to close testimony. Didn't sound like there were any other questions from the board. We'll have some board discussion. So essentially what we need to work through here is sort of how we phrase or, you know, conduct this consideration of the operator's request for consideration of the board order, you know, whether or not we are going to consider it, right? And if we choose not to consider it, what is the path forward so that division staff and the operator can move appropriately forward on the matter at hand, which is the only timely matter at hand, which is the March 2026 financial warranty. Okay, so language around consideration of the reconsideration of the board order, right? Or just saying, if we do not accept this reconsideration of the board order, however, we will direct division staff to do this with the financial warranty might be a direction we would want to head to keep this clean.
Madam Chair.
Yes.
Yeah, this is Chuck. I just want to clarify for the board that, you know, there's nothing wrong with, we back up. It's perfectly acceptable to deny in part and grant in part a request. And so if what you're looking at, and if what deliberation and facts lead you that some of the requests for reconsideration are untimely or whatever, certainly within the board's discretion and authority to deny those, and then grant the one, you know, grant one, but not the other, if that makes sense to everybody.
Madam Chair, this is Wendy Padilla.
Yeah.
And, you know, I was really reading through Grand Island Resources requests on page 202 of our packet, and I would, the way I would frame that is to deny their request to rescind the April 2024 board order and their alternative to hold the order in abeyance 90 to 120 days, but to direct staff to work with Grand Island Resources in the division's normal process, following all the rules and the law to consider reset of the financial warranty, and would leave the timing of that up to our normal process. and I can make that motion and if you would like me to or not.
I'm seeing heads nod. I feel like that sounds like something you could make a motion and then we'll still have time for some discussion afterwards.
Thank you. I make that motion.
Okay. Do we have a second?
I'd like to second that.
Okay. Do we have any discussion? No? Okay. All those in favor, please signify by saying aye.
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 Any opposed, same sign? Okay, hearing none, the motion passes. I'm sure that the division and the operator will work well together to move this forward and appreciate the discussion. So I just in the spirit of keeping this agenda fair to those in the room, there was still a promise of some opportunity for public comment out there. So I would like to suggest that maybe we move item number 13, which is a discussion item on the mine subsidence protection program and audit recommendations, to after public comment, because there may be other folks who have public comment that Cami may be aware of, but I know that we have at least one in the room who still wants to make a public comment. So is there any objection to me moving public comment to the next agenda item?
Yeah.
Okay, sounds good. So, and then Cami, just let me know if there's anyone else you see online, because we've done this move, that it also has public comment either about any of the items we had before us today or just in general. But I will start with the one that I am aware of that is in the room. So if ACRG still wants to make that quick discussion, you're more than welcome to step up right now.
Thank you, Madam Chair. I think, I mean, someone said it's not a mess. I would probably argue maybe it is a little bit of a mess. But I think there's a few things that are really important about the opportunity with this legacy asset. And he's right. No one is asking ACRG to acquire this mine. That's not your role in your jurisdiction. But the time that we have spent vetting this and flying people in from all over the country, and I would also say the world, we recognize that there is a lot of value here, a lot of opportunity for job creation, a lot of opportunity for investment. And it sounds as though there's been a common thread or theme that I heard from the county and the city. And that is, it sounds like they had a really good relationship with the prior operator. And I would like to say that we're giving you that opportunity once again. And I would hate to see the mission for building community, providing jobs, be obliterated over personality differences, because I'm not hearing, based on my experience, anything that says that even the current operators were just always negligent. That's not what I'm hearing. I think it's also important from a community stewardship perspective. GAR asked me to come out last April. And it's been a challenge, because not only am I being handed the blues from its shareholders who want to know, am I really going to purchase this mine and why am I not moving more quickly, but I'm also getting a lot of questions from the community. But I would have to echo what I heard with John and Ben Langenfeld here, is that was well marketed. And we reached out to the county and we reached out to the city and we also reached out to DRMS. I do not know why no one was in the room when I came out last April to quell the fears of the community and SMS's shareholders, that I do intend to move forward with the acquisition after and only if the due diligence around this mine panned out to be a benefit to our shareholders. And the work that we did proved that to be true. And so what I would like is an opportunity to have a good working relationship. I think I could be a real asset here in Colorado, but the only way I can get that is if the board gives me that chance and that opportunity. I don't think that this is one thing or the other. You know, right now we're talking about going back and recalculating the bond amount properly. Obviously, yes, we want that done. But the reality is the issues that GIR has faced over the last couple of years has made it difficult for them to raise money. So if we force this mine into reclamation or abandonment, and they then lose a funded investor who's ready to step up or successor who's ready to step up, how are they going to do that? And I think we've seen 2 travesties here in the community already from abandonment, and it is not better than a funded successor. And so I think we need to think long and hard about that. And then the third that I would say is taking ourselves outside of this room, just as natural citizens. The decisions being made in this country are changing day to day. And the resources that we have in this country are going to be vital to our survival. And silver made the critical minerals list last year, November 2025. That silver is needed. And the last thing that we should be doing is shutting down a very valuable resource that might come in handy to the supply chain of America. And that is something that I'm prepared to come into this community and get done. So I'm not asking you to change anything. What I'm asking for you to do is to give us time. And it's important, as I mentioned earlier, my first fiduciary duty is the United States Securities and Exchange Commission. I cannot put out material information before I go through proper disclosure. There are ramifications of me hastily acquiring a mine, but I think that there's also ramifications of hastily shutting one down. And so the only thing that I'm asking, if we've got 5 years to reclamate, what does it hurt us to give ACRG time to properly value this asset? Because trust me, there will be a fight on both sides on whether or not I properly valued this asset, or if we took it from under SMS shareholders. And once that mine is properly valued, give us the opportunity to have a fairness opinion render. There's already vendors that have been shortlisted to provide the valuation. There's a vendor who's been identified to render the fairness. And then allow us to reestablish the relationship with the community and with DRMS. I'm going to need time for that permit to be transferred. One of the things that we held to and kept our promise on is we've established a corporate foundation called the Cross Caribou Promise. It has an executive director and a board. They were planning Miners Day. They had no idea that the March hearing was going to get the result that it did. Why lose more jobs and more investment in this community because we made a hasty decision? If we're given the opportunity to properly value this, properly transfer their permit, we also have a global firm sitting on the sidelines. You'll see some of their resumes and bios. They're checking in with us daily on whether or not we have the opportunity to bring them in as a new environmental consultant to complete the DMO. They're good at what they do, and we'd like to have the opportunity to engage them to move this thing forward. Thank you.
Thank you. Cami, are you aware of any other folks wanting to make public comment either online or in the room?
Madam Chair, it appears that we have nobody else requesting public comment this morning.
Okay, thank you. From a process standpoint, I thought I saw lunch on the back table. I just want to ask, just for those in the room, would it make sense for you all to grab lunch? This is a, just a board discussion item presentation, and then kind of have a working lunch of that discussion item. Is that okay? Does that make sense?
Yeah.
Yeah? Okay. So, we're not technically adjourned yet, but I would say for those in the room who were here to attend or speak to certain agenda items, that portion of the presentation is over. Give maybe folks, I don't know, 15 minutes to eat your lunch and start up again at 12:15, if that's okay to have. I think Deb Zach's giving the presentation a bit of a working lunch for that education piece. Is that okay?
Oh.
Okay.
Madam
12
Chairman,
Yeah.
I do need to leave in a half hour.
Okay. I think that will be okay for you to leave. Well, let me ask Chuck this question. Are we going to have a reason to go into executive session at all, Chuck?
I don't believe so.
Okay. And Ms. Nelson, I think we still have a quorum. If for some reason we needed to and you needed to leave early, I think we'd still have enough of a quorum to go into executive session. So when you need to drop off, that's fine.
Thank you.
Thanks. Okay, so we'll come back together at 12:15 for this discussion item and grab a good lunch.
I was wondering if.
Anyone want to do this? Yeah. Oh, I got it on there.
They seem like it.
You're welcome. There. Yeah.
It's never good when you're looking down there.
No.
Now I have to hear.
I know, that's what I was.
That's because somebody caught. Or something.
Yeah, that's what I thought, but so. Yeah, what it comes to. No, on these.
Yeah.
No, no.
Yeah.
can't see everyone in the room, but let me know if we're good to go.
You're not gonna get collar. Something.
Hey, Nell, can you give us just like 2 more minutes?
Yeah, no problem. You just
Okay,
tell me.
Just a couple more minutes and we'll be ready to go. I lost my person here. Here she comes.
Okay, no problem. We're not in a hurry. Just let me know.
Okay, no, she just got here, so I just got to turn everything on.
Okay.
And then that's all ready to go. So
Perfect. I'll wait for your cue.
go over to this side.
Oh,
This side.
okay.
You got a presentation or whatnot? You want to go that? Maneuver it?
Oh, yeah. I always forget that that's 2 separate animations.
Yes, you might have to use this.
Yeah, I was thinking announcing it was working.
It's not
for me.
Christmas yet.
I was thinking that one. I just want to make sure you're getting it. You can do this one too.
Oh, okay, cool.
But just how women. You guys got presents.
Really nice ones too. I opened mine in my big mug. My, right, it's a weapon.
I know, right? Multiple uses.
Right?
And it's like elections from the candidates. One's the favorite ties, and one's the just wear a shirt.
We're on?
I think. Yeah. All right, you guys, are you guys ready? No? Word?
I'm ready. Okay, thank you. So we will, this is item number 13. This is a discussion item. Typically we have these for education purposes, and today is going to be a mine subsidence protection program audit recommendations update.
Thank you, Madam Chair, board members. I'm back to talk to you a little bit more about the Mine Subsidence Protection Program, and basically provide an update with regard to the Office of State Auditors report that they put out almost exactly a year ago. We're going to talk through some of the original responses and the timeline, and as well as the recommendations and where we're at as far as taking action on those items. And then because we just found out on the 1st, I believe, of June, that we were reporting back to the Office of State Auditor on our responses and our current process to see what's been going on and see where we're at in terms of meeting the recommendations that they provided to us. This is the original timeline. We've worked through a number of these. Some are in process right now, and that's part of what this reporting is going to be to the Office of the State Auditor. The first one that we've actually addressed through the Office of Surface Mining, Reclamation and Enforcement on the 29th of April, OSM did provide an official letter explaining and then addressing this recommendation 1A, that both OSM and DRMS favor the continued operation of the Colorado MSPP and the solvency of its trust account. OSM has adopted regulations governing the subsidence insurance program, and there's no further need to renew the MOU. So this is basically a kind of a back and forth between DRMS, MSPP, and OSM to determine whether or not an MOU is even necessary. Part 2 is something that we are going to actually address with OSM that they requested as part of that letter that they provided to us. That at least once a year, the trustees, which would end up being you all, and via a report from me as the program administrator, to submit a report, annual report to OSM. And we'll be providing that to OSM by March 31st of each year going forward. And this official letter that this quote is from is actually in your board packet as well. For recommendation 1B, we've actually gone through the process of identifying inconsistencies between the two sets of our documents, the rules, as well as the plan of operations. And we're working with a company called Government Performance Solutions, GPS, to craft a formalized set of standard operating procedures. And that's also part of their recommendation 1C. So once those are completed, we will be able to provide back to the Office of State Auditors full compliance with this recommendation as well as 1C. Just this one. So since January 2026, we have been working with Government Performance Solutions to develop step-by-step process documents for these standard operating procedures. This work is anticipated to be completed during this coming fall. We're probably close to like 80 to 85% complete with this whole project, which has been a significant undertaking in terms of basically laying out, if someone were to come in and take a look at these standard operating procedures, one could run basically this program, because it will include links to templates, links to documents that are standard documents that we provide to the homeowners, as well as things that have to do with reporting, quarterly, annual reporting, invoicing. So it's soup to nuts. Every single thing that you would need to know and to be able to run this program will be in these documents. And then for 2B, which was our the engineering costs, we're in the process of drafting an RFP to solicit home inspection companies to conduct enrollment inspections so that we can further reduce those initial enrollment inspection costs. We've worked with our current contractor to do our best to lower those costs already, but we think that there's still significant cost savings that we can be making use of and obtaining through, I guess, lower, less, I don't want to say qualified, but less significant enrollment inspections. So basically, these are home inspections that require no engineering capacity. They don't need a PE, a professional engineer, stamp signing off on these things. So we're looking at putting out an RFP to gain either some home inspection companies. So basically, when you're at the stage of selling or buying a home, those kinds of companies, because it's a similar inspection. And we already have a form that we've created that they can use, and basically takes them step by step on performing those inspections. And as I stated at the beginning, on the 1st of June, the Office of State Engineer requested a formal status report update for all of their audit recommendations and the ones that we've completed and implemented on June 15th. Our staff, and then the weeks prior, the staff compiled all supporting documentation and completed the status report update, a draft form. And then this draft report is actually going to be provided to the Office of State Auditors tomorrow for their review. And the finalized status report will be presented to the Legislative Audit Committee at their meeting on August 10th, 2026. By the Office of State Auditor. They'll be making that presentation to the Legislative Performance Auditor. We have revised some of the deadlines and provided a table that is comparable to the one at the beginning of this presentation, but we have some revised dates in there in terms of where we're at in terms of implementing various things. We've pushed a few dates out because we want to be able to provide a higher level of detail and a more complete implementation process. to the Office of State Auditors, so. Does anybody have any questions? I kind of ran through things, but you guys hear from me plenty.
I'll just say, from my seat as the deputy executive director, I've kind of been, had a role in reviewing all of this work as it's kind of gone along, and just really appreciate all of your work and everybody who's worked on this. This is a huge undertaking, and you all have done a really great job responding to the audit recommendations and hitting the timelines that were established. So I just appreciate all the hard work.
Thank you, it's much appreciated.
Working with the home inspector, it makes so much sense.
Right, right. And the hope there is that we can actually have more significant cost savings. To your point, on some of these earlier meetings, basically putting more money back into the homeowners than rather than into contractors. So that's our endeavor. All right, thank you.
Thank you. I think we established, just based on that quorum discussion when Ms. Nelson had to go, that we do not have an executive session. Any other items for the agenda that I'm missing before we make a motion to adjourn?
We're good to go. I do believe.
Okay.
Chuck, are we
Do
good?
we-
Yes.
Do we have a motion to adjourn?
I'll make that motion.
We have a second? All right. Any discussion? All those in favor, please signify by saying aye.
Aye.
Aye. All right. This meeting is adjourned. Thank you all so much for your time, and we will see you next month.
Thank you now.
Thanks. Bye.